praying for adjournment of item number 3 to 8, Lordship. Lordship, in this matter, Learned Advocate General is appearing, and the counsel who is assisting him, Lordship, is recovering from his brain stroke, Lordship. So I am praying for listing this matter towards the end of December, Lordship.
This is what?
This is termination of illegal appointment, Lord.
Item
3 to 8.
I am appearing for the petition available. May pray the matter be taken up on 16th.
As agreed to by learned counsel for the parties, let this matter be listed on 16th.
December.
Obliged, Lordship.
December. Obliged, Lord.
Worship, I beg to mention item number 22.
22.
I've taken the consent of the counsel for the petitioner, Lordship.
Hmm.
It can be, Lordship, after 2 weeks, Lordship.
On the prayer of Mr. R.K.D. Chaudhary, learned DSGI, and the counsel for the respondent, and as consented, let this by the petitioner, learned counsel for the petitioner, let this matter be listed after 2 weeks.
After
My lord, that may be fixed, my lord. Date may be fixed.
What date?
Any date, my lord, after 2 weeks. Obliged.
May I please, your Lordship? Lordship, item number 21 is a Pardhar matter before another bench, Lordship. And it is evident from order dated 14/10/25 in the said case, Lordship.
Hmm,
It is a Pardhar matter before another bench.
21. It's a Potter matter.
Pardhar matter before another court and bench, Lord. Lordship may peruse order dated 14/10/25. 14/10. Order dated 14/10/25.
It's a Potter or what?
Yes, both of us were heard and it was listed for further hearing, Lordship. Order is 14/10/25.
Yes. But it just say Potter hearing,
Further hearing.
doesn't say part heard. Matter was heard entirely.
At length, Lordship. It was heard at length. It was fixed on a short date. Then on 16/10, Lordship will see next date, only 1 day thereafter. It was fixed only on 1 day thereafter for further hearing. It was on 14/10. It was listed on 16/10.
Then it was listed on 6/11.
Yes, then Lordship, they had taken adjournment.
Who is for it?
Therefore, the other side.
Do you agree? Mr. So-and-so.
Vijay Sharma, Lordship.
Petitioner, and Mr.
Vivaspur, on behalf of Endika.
Learned Counsel.
On behalf of
Appearing for
Endika. Vivaspur on behalf of Endika.
Endika, Learned Counsel for the APDSL. Have just jointly submitted. Matter matter was heard in part before the appropriate, before the bench other than this court. In view of above, let this matter be listed before the appropriate bench.
Obliged, Lordship.
May it please your lordship, I beg to mention for urgent listing of 2 writ petition, lordship. Kindly allow for next week.
When?
Next week, lordship. Master place.
May please, your Lordship. Lordship, I beg to mention item number 15 and 5 of today's daily list. Lordship, it's a joint prayer. We have taken consent from the other side as well. There's some difficulty on our end today, Lordship.
Lordship, I'm the petitioner.
On the prayer of Mr.
Mbuya, Lordship.
Mbuya, Learned Counsel for the
Health
petitioner.
Department.
Huh?
It'll be from the Health Department, Lordship.
Appearing for Department of Health
Lordship.
and prayer not being objected to by Learned Counsel for the petitioner. Let this matter be listed after
Need it, Lordship.
3 weeks.
Lordship.
No, it's 2015 matter.
Yes, Lordship.
That case two weeks.
Lordship, Lordship.
May I please, Your Lordship, Lordship, item number 14. Lordship, it's regarding to the regularization, and we have informed that the government is in the last stage of consideration, so Lordship may take after winter break.
Hmm?
Lordship, it's regarding the regularization, Lordship.
So
And we have informed that the government is in the last stage for this consideration.
let them consider first.
So,
On the prayer of Miss MS So-and-so, learned counsel for the petitioner, list this matter after 4 weeks.
okay, so, Lordship, and item number 16, it has been infrastructure.
MS So-and-so, learned counsel for the petitioner, submits that the petition has become infructuous. Accordingly, the petition stands disposed of as infructuous.
Please, Lordship.
The record is.
May I please, Your Lordship? Lordship, with consent of the other side, I beg to mention item number 18. Lordship, the matter may be listed after 4 weeks.
Okay, on the prayer of MS,
A Lala,
huh?
A Lala,
For
on
petitioner.
behalf of P. Kotoki, for petitioner.
Appearing
for-
on behalf of Mr. P. Kotoki, learned counsel for the petitioner,
Respondent, I am AM Doctor.
and the prayer not being objected to by Mr. So-and-so, learned counsel for the petitioner. List this matter after 4 weeks.
Must.
Earlier.
I beg to mention item 13 of today's daily list.
13.
Yes, Lordship, in this matter, Mr. H.K. Das appears, Lordship. Today Lordship, he has got some difficulty today, Lordship. So an accommodation for today. only.
2014 matter.
I know that, Lordship. But he is leading us, Lordship.
Mr. So-and-so, learned counsel submits that Mr. S.K. Das, learned counsel, leading in this case, has some personal difficulty. Therefore, press for listing of the matter after 2 weeks. Praise the Lord, list after 2 weeks.
Obliged, Lordship.
May it please your lordship. Yes. This matter basically is with regard to the old pension scheme and the OPS and the new pension scheme NPS. Now, your lordship will kindly take up the dates are important here. In this case, your lordship, at page 27 is the advertisement, page 27. The date of advertisement is 31/1/2001. So, when this advertisement was for the post of junior engineer, the petitioners herein are all selected as junior engineers. So this was on 31/1/2001, 27. So there is no dispute with regard to that. I'm just showing it because of the fact that the dates are a bit important. Then your lordship
Where
at
do we
page
get the
30,
dates?
lordship,
Where do we get the date? That's,
the date is 31/1/2001.
where would we get it?
That is, I think, handwritten, your lordship.
Where?
Handwritten.
Page 27.
Yes, yes. That is the type copy. And the original copy is in 29, which is not very legible. Therefore, the type copy
Where
is
do you get
given.
it?
That was on 31/1/20.
Where do you get it?
It has been written in my, I don't know whether. that likha no. Anyway, your lordship, I'll just verify that. It is 31/1/21, or 2001. Your lordship, thereafter, your lordship, the next page 30,
31/1/2021.
2001, not 21, 2001.
Hmm.
So next, your lordship will kindly turn to page 30.
Hmm.
This is the copy, your lordship, notice, your lordship, for the interview. So here it is, the notice says that out of the candidates who appeared in the written test on 4/3/2001.
For interview, yes,
Yes,
then.
so interview was on 26/11/2004. And the roll numbers were given. Now your lordship will kindly turn to page 32. Page 32. Here, your lordship, this is the order of appointment.
Hmm.
This is of petitioner number 1. The order is 28/12/2004.
Hmm.
This is of petitioner number 1. Then your lordship will see the page 35. Our petitioner, page 35 are the appointment orders of petitioner number 2, 3, and 4.
Hmm.
So
Four
these
pet-
are the 4 petitioners
four
before your lordship.
petitioners, same day,
Same day, that is on 28 December 2004.
as a.
As junior engineer, junior engineer. As junior engineer.
Hmm.
Now your lordship will kindly turn to, in the, just one more thing, your lordship, this is under Assam Electricity Grid Corporation Limited. So AEGCL. This, I just give a bit of the history. Earlier it was ASB, Assam State Electricity Board. That Assam Electricity Board has been, your lordship, there are 4 companies have come under that. These are the 4 companies. One is APDCL and one is AEGCL. There are other 2 companies. So these are the companies, each and every companies have come under the ASC. Earlier it was the Assam State Electricity Board. Now these are all public companies. So now what has happened? They are appointed under this company, that is Assam Electricity Grid Corporation Limited. Now your lordship will, they have joined. I will not go for the joining letters. Now your lordship will kindly turn to page.
This is APGCL,
APGCL, Grid Corporation.
Assam Power Generating Corporation.
Yes, Assam Electricity Grid Corporation Limited.
Where?
That is in the appointment order itself.
No, appointment order, Assam Power.
Generating Corporation Limited.
Huh.
Yes, it is Assam. No, first is at page 32, it is
Yeah.
Assam Power Generating Corporation Limited.
That's what I'm
And
saying.
in page 35, it is Assam Electricity.
I'll disclose it. Specify. The ACB bifurcated into 3 companies, my lord. And the ACB's employees subsequent bifurcation, so the given effect in 2013. And therefore, the employees were distributed among the 3. Earlier, they may be appointed in grid. Actually, the distribution started in 2013, but effective.
No, earlier it was Assam Power Generating Corporation.
Generating corporation,
Yes.
subsequently, the
APGCL.
APGC.
Huh.
And then now it is AEGCL.
Hmm.
Page 35, Assam Electricity Grid Corporation Limited.
Hmm.
These are all companies under the ACB. So whatever my learned friend is correct, these are all companies under the AEGC. Now your lordship will kindly turn to page
So
4,
on the same day, one is Assam
Power Generating Corporation.
Corporation and
And
other one is.
and 3 of them are Assam
Assam
Electricity
Electricity
Grid
Grid
Corporation Limited. There are 3 companies. These are under these 2 companies. Petitioner 1 is under 1 company. Petitioner 2, 3, and 4 is under Assam Grid Corporation.
Hmm.
But they are under this ACB. They were earlier ACB. So after bifurcation, these companies they were put under these 3 companies.
So their ACB is still there.
ACB is actually a nodal.
ACB is not there. ACB is abolished in your 2003 new Electricity Act, where the Electricity Act says that the instead of board, my lord, the company should be constituted.
Accordingly, from Assam Electricity Board, there it has been bifurcated.
Bifurcated into companies, my lord.
It has been come.
3 companies.
3. Now these are. This one person is under
Power
one
generating and power grid.
power grid.
Electricity grid.
Yes.
Yes.
One is distribution, APDCL.
Yes.
But the Sajid Hussain was originally Assam Power Grid, subsequently transferred to AEGCL.
So he is also being transferred to the Assam Electricity Grid Corporation. So all the 4 has now is under Assam Grid Corporation. Now your lordship will kindly turn to page 41. No, there is no dispute with regard to that. I'll come, but only it is under the companies now. Now this is your lordship will see at page 41.
Hmm.
This is important, your lordship. The Assam Electricity Grid Corporation Limited issued this letter to the chief general manager of them. Now, your lordship, here it has been stated under the OM number 26/2008, this was. Now I'll just read that. Pursuant to the office memorandum under reference, I am sending here with the detailed particulars in respect of the following incumbent who is covered under the defined contribution pension scheme along with annexure 1 for issuing permanent pension account number according. Now what has happened, your lordship, when they joined the services, they were under the old pension scheme. Normal, the pension scheme which was followed by the state government or the central government, it was under them. That subsequently in 2008 by this order, so they were now put under the contributory pension scheme, which is the subsequent scheme, your lordship. And your lordship will see at the next page, page 42, the deduction statement of defined contributory pension scheme of the of Mr. So-and-so. So this is how they have started deducting it. Now, your lordship, what has happened? Immediately thereafter, your lordship, when they were transferred to the this particular pension scheme, they came before this on the court. At page 44 is all these four petitioners came before this on. Page 44 is the order of this on the court. Subsequently, this case has come. Page 44. The judgment starts from page 46. The names have been shown here, lordship. These four petitioners were there. Para 2, after participating in the selection process pursuant to the advertisement dated 31/1/2001. This is the date of advertisement. For the post of junior, the petitioners here were appointed respectively in the following manner. So they have been appointed to you. This is given. Now, para 3, referring to the aforesaid information, Mr. So-and-so learned counsel for the petitioner submits that the petitioner would be governed by the Assam Service Pension Rules 1969 for short so-and-so prior to his amendment in as much as the new defined contribution pension scheme which came into effect on 1/2/2005 would be inapplicable in the case of the petitioners. So this was the ground taken in that case. Since they were appointed prior to that, they will not come under the subsequent that contributory pension scheme. Now, your lordship, at page 48, para 4. Prima facie, going by the dates of appointments and dates of joining, the submission of Mr. So-and-so, learned counsel for the petitioner, appears to be acceptable in law, inasmuch as the new defined contribution pension scheme came into effect on 1/2/2005, whereas the petitioners were appointed and have joined prior to it. Accordingly, the managing director of AEGCL is directed to examine the said aspect, including the service particulars of the petitioners, and based upon the respective dates of joining, to pass a reasoned order on the pension to which they would be entitled under the law. So, because of the fact that we have joined prior to this, so court has held that yes, it is prior to the petitioners joining. After the petitioner joining, this contributory pension scheme came into effect. Therefore, it was directed to the managing director. Now, at page 49 is the order of the managing director. This is date is also important. You'll see 1/3/2023. After the passing of this order, this was taken up. I will read from the second paragraph. First paragraph is the reference to the petition, read petition first for earlier filed. Whereas the above mentioned petitioners' contention was that they should be brought back under the purview of the OPS. OPS means old pension scheme instead of the NPS. NPS means new pension scheme. As the government of Assam had introduced the NPS after the date of joining in the company by notification dated so-and-so, which was made effective from 1/2/2005 onwards. Further, GPF accounts have already been opened by the company in their names as per old pension scheme. And whereas the Honorable High Court, by order dated, was pleased to dispose of the aforesaid writ petition with a direction to the Managing Director, AEGCL, to examine the said aspect and pass a written order on the entitlement of the petitioner as per law. Now, Your Lordship, this is the crux of the matter. And whereas AEGCL, being a company incorporated under the Companies Act 1956, is an independent entity, and all state government rules and regulations are not applicable to the AEGCL. And whereas the ASCB and its successor companies were following the CCS pension rules 1972 with time-to-time amendment for its employees who joined prior to 1/1/2004. Now they have come to a finding that they are not following the Assam government rules and regulations, not all, and they are following the CCS pension rules with time-to-time amendment for its employees who joined prior to 1/1/2004. So before 1/1/2004, they are following the CCS pension rules. Now your lordship, the next part. And whereas the new pension scheme was made effective in AEGCL from 1/1/2004 onwards, while OM dated 26/2/2008, in line with the principles of the Government of India as notified by notification dated 22/12/2003, and whereas the amount which has been credited to the GPF accounts of the petitioners was transferred to the respective NPS accounts after the implementation of the NPS in the company. So what it has meant that because of the following the CCS pension rules, they have taken into consideration the OM of the central government, and then which was notified on 22/12/2003, and they have notified that with effect from 26/2/2008, the NPS scheme was effective from 1/1/2004. So that is where the whole matter is. Now, since we are appointed subsequent to 1/1/2004, they say that we were appointed in 28/12, in fact. Therefore, they say that we are not covered by the old pension scheme, but by the new pension scheme. That is what they say by this order. Now, your lordship will kindly turn to the
And
next.
your appointment order also says that they will be under the new pension scheme to be notified in.
I'll come to that. Absolutely. I'll come to that. What has happened, that is also given, your lordship. Now, your lordship will see page 50, next page, and whereas the joining date of all the petitioners is
Okay, sir, I have read that.
Yes. Then come to page
It's
51.
This is the
This is the
memorandum
crux
of
of the-
rural line. Yes.
Now here your lordship will see what has happened and why it has given. 3 March 2023, just 2 days after the order passed by the by the managing director, this office memorandum came into effect. Now here the office memorandum says, your lordship.
Ministry of Personnel.
Yes,
They are
this is-
saying that they are
they are
CPF
guided by the central government pension scheme,
Yes.
the OM, on the basis of, kindly see the OM. They have referred to the OM.
Yes.
That OM is 26/2/2008. Lordship has seen that in the earlier order. Now Lordship will see the office memorandum at 3 March 2023. The undersigned is directed to say that consequent on introduction of the NPS, Ministry of Finance, Department Economic Affairs, all government servants appointed on or after 1/1/2004 to the post of central government service except armed forces are mandatorily covered under the said scheme. The Central Services Pension Rules 1972 and other connected rules were also amended by notification dated so and so, and after the said amendment, those rules are not applicable to the government servants appointed to government service after 31/12/2003. So that earlier rule of CCS rules that they refer to has been amended now. Subsequently, Department of so-and-so, in consultation with Department of Personnel so-and-so, so-and-so, the decision of the honorable courts issued instructions by OM dated so-and-so, giving one-time option to central government employees who were declared successful for recruitment in results declared on or before 31/12/2003 against vacancies which occurred before 1/1/2004 and were covered under the National Pension Scheme on joining service or on or after 1/1/2004 to be covered under the under the CCS pension rules 1972. So they were earlier pension rules. There was fixed time schedule for different activities under the OM dated 17/2/2020. Now the second part comes. Representations have been received in this department from government servants appointed on or after 1/1/2004 requesting for extending the benefit of pension scheme under the CCS Pension Rule 1972, now 2021, on the ground that their appointment was made against the post vacancies advertised notified for recruitment prior to the notification of the NPS system, referring to court's judgments of various honorable high courts and the honorable central administrative tribunal allowing such benefits to the applicants. The matter has been examined in consultation with the Department of Financial Services, Department of Personnel and Training, Department of Expenditure, and Department of Legal Affairs. In the light of the various representations, references, and decisions of the court in this regard, it has now been decided that in all cases where the central government civil employee have been appointed against a post or vacancy which was advertised, notified for recruitment, appointment prior to the date of notification for NPS system, that is 22/12/2003, and is covered under the National Pension Scheme on joining service on or after 1/1/2004, may be given a one-time option to be covered under the CCS Pension Rules 1972. This option may be exercised by the concerned government latest by 31/8/2023. Then your lordship will go to 7. The matter regarding coverage under CCS Pension Rule 70 based on the option exercised by government servant shall be placed before the appointing authority or post of the post for which such option is being exercised for consideration in accordance with their instructions. In case the government servant fulfills the conditions for coverage under so and so in accordance with instruction, necessary order in this regard shall be issued latest by 31st October 2023. The NPS account of the government servant shall consequently be closed with effect from December 2023. The government servants who exercise option to switch over to the pension scheme under CCS Pension Rules 1972 shall be required to subscribe to the General Provident Fund regarding account of corpus and NPS account of the government servant, so and so, so and so. Now what they have said, one-time option has been given to these people who were appointed after 1/1/24, but their advertisement or recruitment notifications were prior to 1/1/2004. Therefore, in this case, the advertisement was in 31/1/2001. They were called for interview on 2001. But ultimately, appointments were given in 28/12/2004 after that. Therefore, these persons otherwise are entitled to be considered for the one-time option under the old pensions. That is what was not offered to us. Before this OM came into effect, the order at page 49 was passed saying that since we were joining after 1/1/2004, we were placed in the new pension scheme as per the central government CCS pension rules, which was modified in 2021. Now, your lordship, on the basis of that, they have stated that all the departments are requested to give wide publicity at page 53, paragraph 9, wide publicity to these orders without fail. So the case, this has to be given wide publicity by all the ministries and departments, and the cases of government servants who fulfill the conditions mentioned in OM and who exercise option to switch over to the pension scheme may be settled by the administrative ministry department in accordance with these orders. So we should have been given the opportunity to opt for the old pension scheme or should continue with the new pension scheme. That was not given. By the earlier order, they said that you are covered under the new pension scheme because you have come under. That order was passed 2 days prior to the OM. Now what they came to your lordship with the affidavit, I'll just take your lordship to the affidavits filed by the.
You apply for this.
Huh?
Did you apply for this?
How can I apply? Because they did not give that is what is the case.
See, did you apply to
We have-
consider your case as a one-time?
Yes, obviously. Why we have come before your lordship?
The order was passed rejecting your claim.
Yes,
Before coming into of this office memorandum.
yes.
It was issued after 2 days. 2 days
After
later.
yes.
Thereafter,
Now what they have to do, they have to issue notification in all departments for
Okay, that,
giving the options.
I'm asking whether you have applied for it or not. That
Okay,
India, see, what,
They have not even given us the option. That is why we have come before this.
no, when you have not applied,
How can I apply
after
without
the,
getting the option?
after the order,
We have applied. We have asked for them that we have to be put in the old pension scheme.
no, that I understood.
Yes.
Now, forget about that. Wrongly or rightly, I mean, as per the earlier notification, office memorandum,
Mm.
since you were appointed after 1/1/2004,
Yes.
you will be covered by new pension scheme. Now, your claim was rejected on the basis of that you were appointed after that. and
Yes.
You are covered not by the Assam
Yes.
pension rules, but by the central government,
Yes.
central civil
Now, when
pension
we-
rule. Now,
When we offered for, I am coming
after
to,
that, after
Yes.
the order, 2 days later, they have issued a office memorandum providing one-time consideration. So,
Uh,
when you come to know the issue, after
Yes.
the issuance of this, did you apply? That's what
yes,
I'm saying.
yes,
Where?
but they have rejected.
Where?
That is why I'm taking your lordship direct to the affidavit filed by them.
Ah.
Now,
But you did
affidavit
not-
filed by them, your lordship will see what they have stated,
but
why
you-
they have not considered. They have given that.
But you have not annexed anything that
No,
to
that,
show that you have
that is not,
applied for.
that is reflected in the affidavit. I'll come to that.
Yes.
In the affidavit filed by respondent number 2 to 5. That is at, lordship is, I think, at page 54.
Yes, yes.
Now your lordship will kindly go to page 55, paragraph 4. I'll come to that. That with regard to a statement so and so, the deponent stated those were not wholly correct. It is a fact that the appointment letters of petitioners clearly state that they will be under the new pension scheme to be notified in due courses. The new pension scheme was made effective on 1/1/2004 by the office memorandum number so and so. Accordingly, the accumulated amount of respective GPA account of the petitioner were transferred to the new pension scheme account. The deponent further stated that before bifurcation of the erstwhile ACT, the Assam pension rule was not applicable to the employees of ACT. Here, this part I am not going. Now, your lordship will see what they are saying with regard to the why they are not giving us the benefit, your lordship. Para 5. That with regard to the statement made in paragraph so and so, so and so, so and so of the writ petition, the deponent states that those matter of record, the deponent does not admit anything which are contrary to and are inconsistent with the records. The writ petition has approached this honorable court by filing a writ petition so and so, claiming that they should be brought back under the old pension scheme instead of new pension scheme on the ground that the government of Assam made new pension scheme effective from 1/2/2005. The honorable court by the order dated was pleased to dispose of the same with a direction to the present respondentry to examine pass a reason order.
Come to
Present,
para-
no,
para
I'm
six.
just coming, just
Para 6.
para 6, yes,
This is the answer.
okay. No, they said in one paragraph, they've said that they were following only 5. That is why I'm reading para 4. Lordship, 1 minute, para 4.
No, I have read that.
Yes,
You come,
there they said
come to
that
para 6. This is the point lies here.
5 items of CCS rules, they say.
It's okay, that we have understood. Para 6, please.
Para 6, okay.
Your affidavit. The affidavit.
Yes, yes, I'm reading that. With regard to the statement made in paragraph so and so, so and so. The OM dated 3/3/23 issued by the additional government of India specifically mentioned about granting one-time option to only those central government employees who have been appointed against the post vacancy which is advertised notified for recruitment prior to the date of notification of the new pension scheme 2003 and is covered under the new pension scheme on joining service after 1/1/2004. The respondent number 2 being an independent entity and as such the board of director has power and authority to frame and adopt any rules office memorandum, the state central government, in the fact the erstwhile ACV wide resolution dated so and so 81 had adopted 5 items of the revised pension rules under CCS pension rule 1972 for the purpose of settlement of pension cases of his employees. Those 5 items are voluntary retirement, amount of pension, commutation of pension, family pension, and retirement death benefit. In order to rationalize the settlement of all the pension matters for his employees and all his successor companies, the ACV issued office memorandum dated so and so. By the said office memorandum, it is confirmed adoption of 5 items of CCS since November 1981, subject to limitation of quantum of cash benefits to be admissible to the employees. Now, your lordship, and they have taken a resolution on that, para 7. Each and every decision of the central government respect new pension scheme is not binding on respondent number 2. The board of directors by resolution dated approved and adopted the new restructured defined contributory pension system in line of the principle of Government of India notification dated so and so. Now what they are saying is that they will follow whatever they want to follow from that, whatever they don't like, they will not follow. Now that 2 annexes they have given you. In annexure at page 63, page 6, no, page, yes, page 63. Lordship has got that, annexure. This is the extract of the resolution. Now your Lordship will kindly turn to page 64. The ACB, this is with regard to the ACB's resolution in its September 1981, has adopted the following items of liberalized pension rules under CCS Pension Rule 1972 for the purpose of settlement of the pension cases in respect of employees. So I'll, here your Lordship will wait for a moment. I'll just make my submissions. What they meant by this. Interpretation is important, your Lordship.
Yes.
Yes, so in page 64, when they say the settlement of pension cases in respect of employees, it is with regard to those employees whose pension cases have to be settled. And the settlement is with regard to voluntary retirement, amount of pension, commutation of pension, family pension, and retirement death gratuity. This is with regard to which the earlier resolution of the ACB in September 1991 was adopted and under the liberalized pension rules under 72 rules of the CCS pension. So what they meant to say that those employees who were there in the company who is retired, they will be considered who has retired under voluntary retirement or the calculation of the settlement of the cases. It is not a fixation of pension. It is a settlement of cases have to be done under these 4 heads are considered. Now this is not that they will follow only this. Now your Lordship will come to the second part. In order to rationalize the settlement of all pension matters for its employees and all its successor companies, the ACB by resolution number so-and-so dated January 2011 has confirmed its adoption of the CCS pension rules 1972 since November 1981, subject to limitation of quantum of cash benefits, therefore as admissible for the retired expired employees. Cash benefit regarding retired expired employees of the government of Assam from time to time. Now the second last part. The ACB has further decided to continue to follow the same along with the amendments made so far and to be made in future by the Government of India in the rules quoted. IB. So what they meant? They meant that in future, now whatever amendments made and whatever future amendment to be made by the government, they will follow those amendments only. They are not going to follow the Government of India rules. This is it. So what they meant to say is that we will be following the CCS rules along with the present amendments, along with the future amendments that will come. So that is what they decided in 2011, 13 October 2011. Now they are referring in the affidavit, our cases are not considered because we do not follow the CCS rule in entirety. We follow only parts of the rules. Once you follow, now the question will come. Your Lordship knows the service jurisprudence. You have your own pension rules, nothing to say about it. You don't have your own pension rules, either you're following the state government rules or you're following the CCS rules. Now they come and say we follow the We don't follow the state government rules, accepted, fine. We follow the CCS pension rules, accepted. Now, if you are following the CCS pension rules, then they come up and say in their affidavit, no, 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 we don't follow the whole CCS pension rules. We follow only this part of the pension rules. So that that is why you are not entitled for the NPS. Sorry, OPS. How can that be? Can it be following particular points from certain rules? And they were pointing it out with regard to the settlement of the cases. Settlement of the cases of the earlier cases are under the 1981 rules, which was there under the ACB, that was settled. And in that cases, obviously that will be under the retirement, gratuity and all. Here it is nothing like that. So that is my case, is that how can you do that? Now, your lordship will kindly take up my additional, my reply. In the reply also, your lordship, the rule of 2023 have annexed. Now, this rule of 2023 is what it has been given, already annexed by them. Now, your lordship, what I would like to point out, here in the rules,
Rule of 23 means what?
this one, the new one, that your lordship will find at page 73, wherein this part, your lordship, that was office memorandum. Office memorandum was there, which I have shown to your lordship, where the one time was given. Now that has come in 13/7/2023, and this was directed. That is at page 73. Here
Is
is also
under all India.
this is for all India, all state governments and union territory. Now your lordship will see, this is the same thing has been written, so I'm not reading it. Page 77.
No, this
I need
page 73 is what?
73.
It's a letter.
Yes, it
to
will
the
letter
chief
to all the chief secretaries to follow this
The OM.
one time.
3/3/2023.
Yes, to follow. And that, your lordship, how they will follow, they have given at page 77, your lordship. These are the formats. These are the formats given, how they will. This is for the drawing and disbursing of
From the new pensionist to old pensionist scheme and opening of GPF account.
how they have, this is the format, how they have to be doing it. So format has also been given. The mechanism has also been given at page 80. When the
For those whose advertisement and the vacancy arose before 1/1/4,
yes,
although appointment is made thereafter.
yes, that is being
Yeah,
given.
that's better.
Now, your lordship, now how? Because they are already converted to NPS. So it was converted to NPS in 2008 itself. This has come later on. Therefore, how the procedure should be done to convert it back to the OPS, that has been stated, the mechanism and procedure at page 80. I'm not reading that. It is how they will transfer the money from NPS account to the GPF account
Yes.
and all. I'm not reading that. That is their duty to do it. Now, your lordship, apart from this, what they have done, they have also in page 71, this is just an example I'm giving, page 71 of the same. Here they are giving, this is a notification. This is not connected with the junior engineers, but this is notification at page 71. I'll just read this notification. In line with the office order dated so and so, the following procedure has been adopted for payment of pension benefit along with DCRG to master role workers, family workers, of expired employee previously covered under NPS. So they were covered under NPS, originally engaged, project thereafter regularized on 1/6/2005. Office order so and so dated IMA. For the existing regularized master workers, now they are giving at the at serial number 2. Upon receipt of application, necessary action shall be taken by DDO to record and the respective service books of conversion of the employees from new pension scheme to old pension scheme with intimate of same to the GM Swens. Now what I have done in the master role workers who were ultimately regularized on 1/6/2005. We are prior to that. These persons were regularized later, but since they were appointed earlier, they were also given the option of they were earlier in NPS, they were given the option to come into OPS. And the option they have been given. Why? In our case only, these 4 petitioners under the junior engineers, it has not been given, saying that we are only considering it for a part of it, not all. How can you do that? You have done it for your own master roll employees.
What about the others? This master role,
Master roll have been.
you are junior
granted.
engineer.
We are junior.
What about the others?
Others are all who have opted have been given. We have not been given.
Right.
This is why we have come.
So now your entire case hinges on this OM 23.
OM 2023 and subsequently.
Forget about whether you are entitled earlier and all those things. It's a subsequent which they, I think, prima facie ought to have considered.
Their ground was that we have not adopted the whole. That is the ground.
Yes. Any judgment you would like to rely?
Judgment at this moment I have not.
You are
Actually,
only,
part I am
only relying
basing on the OM and the.
03/03/2023.
If required, your lordship, if your lordship completes the
We
hearing,
will
I
not
can.
consider
Yes.
whether you are entitled
Mm.
under the all pension scheme OPS
Hmm.
in view of the appointment being made after the
1/1/2000.
coming into 2004,
But
although the vacancy
advertisement
arises
was in
in
2001.
prior to that.
That's
We'll
the basic
consider
step.
whether we have to look, we have to consider whether on the basis of the office memorandum 03/03/2020, your case has been considered, whether you have been given option or not.
Yes.
You're saying that you have not been given.
No, I have.
So
yes.
whatever the arguments they have taken, and as such, will not interfere with the, I mean, we will not say that because the grounds of rejection by this impugn order is something different. It's
It
a
is something-
subsequent development. I mean, you should, why is a one-time option, you
Yes.
should have been given a
Yes.
one-time
That is-
option, that's all.
Yes.
So according to you, it has not been considered?
Not
No option
considered, and
was
that
given?
the ground that they have given is that they have not accepted the whole
That
NPS.
cannot be. Yes, sir. How can you adopt and apply bits and pieces,
No, it's not a
bits and pieces?
It's not a pick and my lord, pick and choose.
Not
it's
pick and
not a
choose,
pick and choose.
bit and pieces,
Ah.
bits and pieces.
My lord, pieces. My lord, what happens, it's a company. First of all, you have to understand, this is a company, registered under the Companies Act. It's not a central government undertaking.
Good.
It is not a state government undertaking, it's a company, my lord.
Sir,
I-
but you have already said you are following the CCS pension rules
No, no,
1972.
That's coming, I am coming to that.
Ah.
I am not disputing, I am annexed those documents.
Ah.
What I am on, my lord, I am not adopting the CCS rule. Toto. I am, your lordship, kindly have a look on our resolution. That resolution, where the ACB took the resolution for certain purpose, these 5 subjects we are following. You are following. Madam,
Yeah, you follow that.
no, my lord, for 5 items.
It's a, sir, now matter is very simple now. In view of the office memorandum 03/03/20, which was issued 2 days later of your rejection order, right? Whether you have given an option or not.
No, my lord, I am coming to that.
What I could understood, I can understand from what I have understood is that by your affidavit, although the office memorandum issued, although you adopt the CCS pensions rule 1972, all the office member thereafter and arises out of
No, my
that,
lord, your lordship
you
is,
don't adopt it
no, your lordship is.
because
one-
you are a company.
No, my lord, what I am on, my lord, what I am on, your lordship, I want to justify your lordship on this point. When the central government took the scheme, my lord, pension scheme, that pension scheme was not adopted by the government of Assam. They frame a pension scheme in the light of, my lord, central government, the Assam government. Assam government pension scheme is a different scheme, my lord.
No, we're not concerned
No,
now.
well, I'm coming to that. Why I am submitting before your lordship that my humble submission before your lordship, first of all, the CCS rule or the notification itself for to whom
the 2003 notification. My lord, they have annexed subject, my lord. Coverage under CCS rule in place of national pension scheme of those central government employees, my.
No, that we understood.
My lord.
Yep.
Oh.
Facts remain that you adopt and you implement the CCS pension rules. That is what you have
No,
said.
my lord, we never adopt as a whole, my lord. We adopt, your lordship, kindly have a look at my resolution, my lord. That your lordship will clear. My resolution at page 64, your lordship, kindly have a look on it.
Yes.
Your lordship, kindly line, the ACB White resolution dated so and so had adopted the following item, of the liberal pension rule, CCS rule 1970, for the purpose of settlement of the pension cases in respect of the employees, my lord.
Yes.
My lord. Here,
This is for the purpose of settlement of pension.
pension cases, my lord. Settlement of pension cases, those pension cases pending.
No, the issue is now conversion from now reconversion from NPS to
No, my lord,
OPS.
that's why, my lord, I am
The
submitting.
office memorandum provides for a one-time option.
No, each and every state government has their own scheme, my lord, own pension scheme. If you look, we have the 2005 pension scheme, state government.
No, you said you don't adopt the state government pension scheme.
Yes.
You adopt and the CCS pension rule
No, my lord,
applies.
we have not.
You have said so.
No, my lord, if you read
In
my.
your impure order clearly says so.
No, read my 63, page 63, my lord.
No, you come to your order.
That's not adopted, following,
Following, yes.
following, my lord, not adoption.
Yes.
And that is the language in here. Following, my lord, that's not adoption. My
Being a company incorporated so and so independent, all the state government rules are not applicable to AJ, whereas ACB and a successor company were following the CCS.
following, no, not adopting. Adopting and following is different, my lord.
You are following.
Yeah, I am following what I am following here is there. Resolution is there, my lord.
So if you follow the rules
My lord.
or the scheme of the central government, you have to follow that one-time option also.
No, my lord, what I am on, my lord, if your lordship, what is there in
The central government has considered on the basis of the representation and
the central employee.
orders of the High Court, basically for.
No, my lord, your lordship is
Of course, it's
absolutely
for
right.
central government only. They will not issue for you. You know that.
Beg your pardon?
They will not issue for the companies. But since you are following a central government,
No, my lord,
you have to follow the consequential,
I understand your lordship.
office
what-
memorandums.
I know, my lord, what I want to satisfy your lordship.
No, I have understood.
What I am I said is that this is a company, my lord. I can follow the state government rules. That doesn't mean that whatever the state government rule did, I have to follow it. Because my company, it is not a government undertaking, my lord, or government entity. If government entity, my lord, it's a company guided by their own
Yes, I
MOU and my lord,
Do you have your separate scheme?
entity.
You are not following, do you have a separate scheme?
Yes, my lord.
If you are not following every
No,
circle
my lord,
person-
that's why I have annexed the scheme, my lord, and your lordship kindly have a look at page 60. What
this?
say page 60 says? Kindly have a look on it, my lord.
It's 60.
Yeah, that is the scheme, my lord, our scheme. In the interest of welfare of employees of the board, so and so, has adopted the new restructured defined contribution pension scheme. Your lordship, pension scheme system in the line with the principle of the government of India as notified so and so, issued by the Ministry of Finance, in case of new entrance to the service of the replacing, my lord, kindly note it down, replacing the existing system of defined benefit pension scheme system. Am I clear to your lordship now? My lord,
Yes, this is on the basis of that
in the light of, my lord,
pension scheme of the.
in the light of pension scheme, and also your lordship kindly, by this notification, two things clear, my lord. Two things. One is we are framing this scheme system in the light of central government and replacing what, my lord, that is there, my lord, defined benefit pension earlier. Has your lordship got it?
Yes, yes, that is same thing.
My lord, earlier, my lord, prior to this memorandum, new scheme, earlier our system is defined benefit pension scheme. It's not, we are not calling it that central rule is applicable. Our scheme is, system is defined benefit pension scheme system.
Where is that earlier one?
My lord, first paragraph, page
No, where is that earlier one? Existing
earlier,
defined benefit pension scheme.
replacing the existing system of defined benefit pension scheme.
Where it is? Do you have the copy?
No, my lord, if your lordship want, I will paste it before. Right now, it is not necessary because of the issue was not there. My lord, issue was his whether central government's instruction is in binding on us. That's the question.
No, it's not a binding. You are since you are following.
No, my lord, that is why I am coming.
Since you are following the principle.
I am following the principle of a scheme, my lord.
No, principle. The scheme.
Scheme.
Why you cannot follow the
My lord, that is the question, my lord.
to the prejudice to the employees?
No, my lord, what I am on before your lordship. One thing is clear.
And more so,
Oh.
for, of course, that's why I've asked for whatever other employees, for
No, my lord.
master roll worker who has been regularized,
Ah.
their service has been regularized
Regularized.
after in 2005. You have considered, you have.
Yes, my lord, master roll workers who has been regularized in 2005, they have not been joined in 2005 or their service is not prior to 2004. They are continuing long back and therefore their scheme, because of there is a judgment of this court, the 10 years or something more, they are entitled for, because their appointment goes back to the original first appointment. So they are in fact originally covered under the old pension scheme, master roll. Originally, if regularized earlier or they have been appointed regularly, master roll, my lord, yearly 1 year appointment appointee will not get the regularization. That is a clear and straightforward case. Master roll appointment long day back, 10, 12 years, 15 years, my lord.
So according to you, although you are following the principal scheme of the central government,
Huh.
new pension scheme. I
Huh.
mean, the principal,
No,
Scheme.
in the, we are,
the consequential or the subsequent orders,
we
you
may
are,
not
you are,
follow
you are
it.
not bound to follow.
Bound to follow.
Therefore, you don't want to follow. Either you are not following.
In a sense, my lord, in a sense, my lord, what I am on, my lord, before your lordship, normally, we are framing a system, my lord, in the light, some policy is there, but that policy, we like it. A company, I like this policy of the government. Accordingly, in the light of that policy, I am following it. But in subsequent every action, we are not bound by following, bound to follow it. Because it is our the authority decide. It is our the prerogative. It is apart from that, my lord. Well, his appointment letter, your lordship kindly already note it out. That your new pension scheme, it's a company, my lord.
Yes, we have seen it, but the problem is after.
No, my lord,
Subsequent,
no, my lord, I totally agree with your lordship, subsequently, but at that time, new pension scheme of the central government is in force. When we issued the appointment order, when we issued that appointment order to him, new pension scheme of the central government already was in force,
yes.
my lord. We never said that whatever the central government scheme is there, that will be applicable in the appointment letter. We said, what we said in the appointment letter, the new pension scheme, that will be
Obviously, because you are following that new pension scheme,
which one, my lord?
new pension scheme of the central government.
No, that's the difficulty I face here. My lord, what the problem is that we are not following, adopting that policy.
I was saying it now. Earlier I said adopting it.
No,
I'll go by your words.
following, my lord. We are following it.
Followed, and you are following that.
My lord.
Why you cannot consider the subsequent the office memorandum? That's why I have indicated
my lord.
we are not going to decide in view of the appointment
That
having been made after 1/1/2004, although the vacancy and the advertisement was issued in 2000
my lord,
prior to that,
I'm coming to
prior
that.
to 01/01/2024. But in view of the issuance new office memorandum issued by the central government, of course for the central government, since you are following the principal scheme, why not consider?
No, my lord.
Because it will, because this court also, while directing you to consider your case,
No, this
has
court,
observed that.
no,
there-
earlier they came with a plea that Assam government rule is applicable, Assam government framed this rule, so therefore we are covered. In their earlier case, they alleged that Assam government pension rule is applicable. In
No,
fact,
that's why we agree. We agree that we'll accept that you are not following the Assam rules now.
rule is.
You are following the central government scheme, new pension scheme.
In the light of, my
But
lord,
in that connection, when any decision is taken by the central government, I think,
no, my lord, that is the,
you see, that way. you
that is
cannot
the
say
Lakshman
that
Rekha, my lord.
the provisions or the scheme which suits you, you just adopt it and discard the provision which will beneficial or advantage to the employees.
Rightly, your lordship
Well,
said,
if you are a company, it's your own
no,
employee.
rightly, your lordship said that had it been a case that I adopted or followed in toto of the central government scheme, rules or scheme, then a different thing.
You didn't say that you are following in Toto or in.
No, my lord. Some guidance I took from the central government scheme in the light of guidance. That does not mean, my lord, that I would follow the each and every central government subsequent action in respect of that part. My lord, what is a entity, we have to consider all aspects of the board. And considering all these aspects, when a board took a resolution, that earlier our system, we abolished it. Earlier, the board never said, while taking the resolution, that earlier this central, in the light of central rule or following the central rule, the system was framed. Earlier system was there. That system was abolished and in new system was introduced in the light of the central government scheme.
And this means what? You are following the central government scheme.
Following and my lord, that's the difficulty. Following means I need not require it to frame a scheme. Following means I am following it.
This
That is, no, my
Your
lord.
affidavit, you said you follow this.
No, my lord. We are following the pension central government scheme that only 5 subjects, not entire entity. My lord, that is why for settlement of those cases, pending cases, that resolution I have enacted.
Sir, this is something different. Settlement of that 5 points,
Uh-huh,
5 areas.
uh-huh,
There's no dispute. You can have that.
For that only
For
central,
settlement of pension,
uh,
their case is conversion from new to all pension in view of the office memorandum. And I have understood that although you follow the scheme, all right, new pension scheme of the central government, but every orders or the provisions you are not bound to follow as a company. You have your own scheme. That's all,
that's all.
isn't it?
That is what, in fact, what your lordship point out, that the new pension scheme, pension rule, CCS pension rule, we have very specific, my lord, that only these subjects are ruled. Therefore, we can't say that the CCS rule is in fact applicable to us.
Sir, what ails you from considering as per the office memorandum 03/03/2023?
My lord, that as we are not a central government entity, our authority is based on the company. It's a company, private company registered under the Companies Act. I can take guidance from this judgment also, Supreme High Court judgment, that this is the law, or this is the observation in a case. That guidance we can take for the benefit for all. But that does not mean that in toto.
Just asking, what ails you to adopt to follow this one-time option?
That I can, being an advocate is difficult to say.
Not you.
Madam,
company-
my authority,
They have also used the word adopt. It is there at page 63. He's saying they have not adopted.
which one?
They stated, resolve that, at page 63, I'll read that. Resolve that the board do hereby approve and adopt the new structured defined pensions.
I mean, these,
They have adopting it.
my lord,
They're
that's,
following some part, they are not following some part. They are saying that, but they have adopted it. And that is in line with the principles of government in India notification dated so.
when they,
So when you say adopt,
when a resolution was placed before the board of meeting, my lord, board always adopt it. The resolution that an agenda was placed before the board. Adopt in the new restructured defined contribution pension scheme. Yet nowhere the central rule scheme is applicable.
they have also in the page, I'm just pointing it out, page 200, page 64 also, in the last paragraph, I'll read that, the last paragraph. In order to rationalize the settlement of all pension matters for its employees and its successor companies, the ASCB by this resolution dated so and so has confirmed its adoption of CCS pension rules 1972. So here is also the word adoption. They are not following is a different. Following and not following is fine. Is correct. But adoption is there.
My lord,
Now,
read
he might-
read always full line. Yeah,
Adoption
read the adoption of
since 1981.
80, November 1981, and the first line of the office memo, the ACB by resolution dated so and so September 1981. And therefore that it relates to that resolution, ACB resolution.
You just read. Subject to limitation on quantum of case benefits thereof as admissible for the retired expired employees of the subjects from time to time.
Government of Assam, those are
The ASEB further decided to continue to follow the same along with the amendments made so far and to be made in future by the Government of India in rules quoted here. Sum and substance.
No, my lord, these are in order to rationalize the settlement of, your lordship has to read the entire.
That's what I'm saying.
Mane,
You are relying this why?
no, I am,
Settlement of
exactly. It is not a case of settlement of pension payment. It is a case of whether they are entitled to the old scheme or new scheme. That's the question. It is not settlement, my lord. Our case is that for settlement of pension, any dispute, we have to refer to that for settlement. Why the word settlement is come? My question, my point is that this is the dispute, any dispute can be settled through these are the things. And therefore what I submit, my lord, the central government scheme or any notification is not applicable because it is a separate entity governed by the ACB, Indian Electricity Act 2003. ACB
unless you decided to follow.
follow or adopt.
The 2030323 has
Yeah.
not been,
No, neither adopted nor
there's no decision, there's no resolution to follow that.
there must be a both discussion, it is up to the board. And without that, my lord, because of that, our scheme was placed before the board and board adopted the scheme.
So as on today, there's neither the decision or resolution to adopt or not to adopt.
No, not there.
Take a decision.
How can I say, my lord, take it? I cannot say. And,
Not you.
my lord, ACB
Company, I'm saying, sir, not you.
No, my lord,
How can you-
that's-
I ask you to decide as a,
It's
as a,
very
as a,
difficult to say from my side.
as a lawyer, how can I ask you to decide
Right.
for the company?
My lord,
that is why
What I'm referring is you means the company.
that same company, in case of the junior engineers, have stated that we are not adopting the rule. We are only adopting the part of that which is favoring them. But in the case of masteral workers, let us assume they were employed whenever, whatever date, we are not on dates. Let us assume. Then why they have given that option from NPS to OPS? That's what I'm saying. They have
Okay.
given the
Because
option.
they are-
What is given in one part would not be tasked. That's
They
it.
are-
If they are not adopting at all,
They
it
are
would not have been adopted at all.
their appointment goes back to
We
the
are not on appointment.
prior to 10. That's why
Or-
they are
Option is
entitled,
given.
my lord.
They were in NPS. It was not that they were not in NPS.
No, my
If
lord,
he says that they were not in NPS, they were in OPS, there is no question of giving them the option. If the option has been given, on what basis the option is given? The option is given on the basis.
only thing, my lord, I would rely on judgment, my lord, if
Hmm.
your lordship allow me. But when there is an appointment order, that clause is there, my lord. It's a- I have relevant extract I am giving you, your lordship. I mark it.
Not, you are, no, it's, issue is not of appointment now.
No, my lord, appointment, that's why I'm.
There's no dispute.
Appointment
There's no
condition is there.
dispute that there was a.
No, my lord, condition.
The condition came subsequently, your lordship, not at that point.
Maybe not relevant for this case, but I relied on this. When you accepted the appointment order, now you cannot say Samarthal, Marcus Samarthal, that I had it.
Which one? Para?
Then I have mark it, my lord.
Para 48. You've just given 2 pages.
My lord, it's a long judgment, my lord. Only paragraph, that relevant paragraph.
Friend is saving some money.
The company is so poor, Warren. How do you know?
Yes, my lord.
It
Company
is a
has not paid-
fundamental principle of his own accord, except a contract or certain terms and work. works out the contract, he cannot be allowed to adhere to and abide by some of the terms of the contract which approve.
This is a
This is
maxim, my lord.
Bihar Biri, new Bihar Biri lives. It's a principle appropriate and reprobate.
Principle of appropriate and reprobate. When you accept it and you one part you accept it and one part you cannot accept it.
This is against you. One part of the scheme you are following, the other part.
No, my lord,
This is a
we have not,
consequence.
we are taking in the light of the scheme, my lord, this is not going my against. There is no document that I have been accepted that document.
No, you said that although you are following the principal scheme, but the consequent, subsequent orders or office matter or decision or scheme, you are not bound to follow, and you are not following. Like the present one, the office memo OM 03/03/2022, you are not following because you are not bound by it.
Bound by.
Although you are following the scheme.
Not following the scheme, we are in the light of, this is our scheme, my lord. This scheme which we introduced or adopted, it is our scheme, not the central government scheme, my lord. This is our scheme, we frame it. In the light means spirit is there, but the scheme was formulated by us and we adopted it. And similarly, state government's new pension scheme is there. Similarly, state government also formulated. That is different.
We are not concerned about the state government now. Only issue is whether you are permitted to follow the principal scheme and then not to follow the
That's up
scheme.
to the central government of decision to provide benefit to the authority person. You know,
Employee.
that may not be acceptable to our board also. That's
We have
maybe.
not taken any resolution as on today.
Maybe.
When you have already adopted, followed the scheme, principal scheme, subsequent orders under the scheme, providing a one-time option, you have not taken any resolution whether to follow or not to follow.
That is not mean.
This may not be binding,
No, that is not.
but if it is prejudice, if it creates prejudice or disadvantage to your employee, you should consider that whether
well,
you adopt it, you apply.
Actually,
you
you're
should
right.
apply
Your
or
Lordship
not.
is right to that extent, but problem is that the board of directors, what they feel it, I answer. It is difficult for me to answer those questions.
No, facts remain that you have not taken any resolution.
No, because
No resolution, nothing.
no resolution, because in fact, that letter goes circulated to all departments, not for us. There is no such direction from the central government even. That other authorities also followed this. Only central government, the circular subject is very clear. Subject is only for the central government employees, and whether that
And
Can we
that scheme which you have followed, it's only for the central government, it's also not for.
no, my lord, that is a direction issued to all state government. If your lordship go back to that history, then this central government frame a scheme, because it is a
Is
it is a my lord,
it
pension.
says that it will be applicable to companies.
Which one, my lord?
The scheme framed by the central government, new pension scheme.
No,
Then
we are, my lord, what we on.
you
The-
said
No,
that
my lord.
the new office memorandum
Ah.
is only for a central government employee.
Yes, man.
And equally, the principal scheme which the central government has formulated, which you and which you have adopted, is it provides that it is also applied to the
No, my
companies?
lord, I'm coming to that. I'm coming to that. Then your lordship has to. I have to say the back history.
No,
Pen-
I
pension-
understood what you
No,
are, what
what-
you are saying, that you, in the light of the central government scheme, you have your own separate scheme, Therefore, any orders or decisions by the central government in connection with the principal scheme is not binding on you. You being a separate entity, being a company, you have your own scheme
Yes.
which you have already
Yeah.
adopted, formulated and adopted. That is what you are saying.
Yes, because of,
Therefore, you are not bound to consider or apply or adopt or follow the subsequent orders
that's order.
or the decision of the central government.
That speaking order
That's all.
reflected. Yes, my lord.
Okay,
Well,
close it.
Hmm.
Heard Mr. Y.S. Mannan, learned counsel for the petitioner, and also heard Mr.
that's what.
Kotogi, learned standing counsel. What do we call it? APDCL,
AEGCL.
AEGCL. Challenge made in this writ petition is to the office order dated 01/03/2023, passed by the general manager within bracket HR bracket close I/C in charge, AEGCL, AC Weber. The claim for benefit under the all pension scheme of the petitioners are rejected. The petitioners have also prayed for direction to implement the office memorandum dated 03/03/2023 issued by the Additional Secretary to Government Ministry of Personnel, Public Grievances and Pensions, Department of Pensioners Welfare, whereby a decision has been taken to provide one-time option to opt for coverage under CCS pension since 1972, within bracket now 2021 bracket close, to those employees who have been appointed against the post or vacancies which was advertised or notified for recruitment prior to the date of notification for National Pension Scheme, i.e. 22/12/2023, and is covered under the National Pension Scheme on joining the service or not after 01/01/2004. Pass the order. We'll consider and pass the order.
Also.
Let's see which way it will turn.
Well,
I'll agree.
obliged.
Much obliged.
Yeah, please, Lordship.
Yes.
Lordship, I am aggrieved by prolonged suspension. State government, which is in violation of their own office memorandum as well as Supreme Court order, which has also been followed by your lordship in orders in various cases, lordship. Lordship will note that I was suspended. I was working in the Nadua.
Ready?
I was suspended from my service on 7/2/24, lordship. I was working as a land records assistant in the Nadua Revenue Circle, Biswanath district. Subsequently, lordship, I got a bail order because I was suspended due to my arrest. I got a bail order on 6/3/24, lordship. I submitted a representation to the DC that I am out on bail. Please reinstate me on 18/3/24, lordship. Charges were framed against me, lordship, 27/3/24. But in light of the office memorandum and Supreme Court judgment, as soon as the charges are framed, an extension order has to be passed for the suspension, giving the reasons for the extension, lordship. I was only served with the show cause. I was not served with the extension orders. Subsequently, lordship, they have submitted an affidavit in opposition in January 2025, saying that my DP is on the verge of completion and the result will be out any moment. Now, 10 months have elapsed, lordship. It was completed in January 25, but they have not been able to give the decision till now.
No, whether your suspension, you are against the suspension,
I'm against.
not against the DP.
No, I'm
Not against the DP.
Only suspension, lordship.
In that case, only what we have to see is whether
Lordship.
your suspension was reviewed within within 3 months or within
Lordship.
time required under the rules.
Lordship has disposed of a series of cases.
No, it's okay. Let us come to the facts.
Yes, lordship.
When you
On-
were suspended, were your suspension order reviewed within in 90 days?
No, lordship. That
That
90
is the
days,
issue.
when the charges is not given within 90 days,
Hmm.
then that 90 days principle is.
Yes.
But when the charges has been given to me, the
Hmm.
extension order has to be with the so cause notice, lordship. That is the law. I'm showing it to lordship.
Is there any extension?
The extension, they say that they have done in the month of May, after a lapse of 90 days, and that also they have not served it upon me. After coming to this court, they have served the extension orders to me and saying that they have sent it by general post. They serve the show cause personally, they send the extension orders by general post, and they say that they have served by WhatsApp.
Have you received it or not?
No, lordship. After coming to this court, I have taken a copy from them, and then I have filed an additional affidavit.
Saying what?
That the grounds which have been given in the extension order that are not sustainable. Lordship, the Supreme Court judgment in the case of Ajay Kumar Chaudhary, it says that when the charges are not framed within 90 days of the suspension.
So it's not your case.
Lordship,
It's not your case.
there are two parts, Lordship, in that.
That's why I mean, what is your case?
My case is charges were framed within 90 days.
So first the thing is goes.
Lordship. Charges were framed within
Yes.
90 days,
Hmm.
but according to the Supreme Court judgment also, with the charges, they have to serve an extension order mentioning reasons for extension. That has not been done in my case, Lordship.
Where it is.
I'm showing it to the Lordship. I think. एक और copy दे दो उसमें. Yes. Lordship, paragraph 17 of this, your Lordship's judgment. Lordship has disposed of series of cases. This case, in principle, was relating to charges not framed within 90 days, but Lordship has appreciated the other part also in paragraph 17. Last 6 lines, Lordship. If the memorandum of charges order is served, a reasoned order must be passed for extension of the suspension, Lordship. That is what I'm trying to point out.
If the memorandum of charges, order is served, a reason order must be passed for extension of the suspension. Yes.
Yes, so Lordship has,
So in your case, memorandum in charge,
has been served upon
we're
me.
not concerned about the review of the review within 3 months. We're
Not
concerned.
3 months. Along with the show cause, they ought to have served. an
No,
extension.
we're not concerned, the first part, saying that the suspension order should be reviewed within 3 months.
Because charges were framed within
If
3
it's
months.
not,
Yes, Lord.
yes. So if the charges is framed
A reasoned order should be passed their way, along with.
for extension of suspension.
Yes, Lordship.
Your
But-
case is that you have not been, no order was passed
Yes, Lordship. So Lordship, in
for
principle,
extension.
this judgment which your Lordship has appreciated just now, since in this case it has been observed, but it was not the case in this case. So I have submitted another judgment of a coordinate bench, Lordship, Utpal Kemprai. The facts are exactly similar, Lordship. Charges were framed within 90 days. Extension order was not served with the show cause notice. Extension order was not served within the proximity of the show cause notice. So relying on the same formulation, Lordship, the court had directed reinstatement.
There is also arrest by the director of business.
Yes, Lordship. Entire thing, all facts are same, Lordship.
Utpal Kemprai, Lordship, perhaps no review was done, Lordship. So I'm sorry to interrupt, Lordship.
Huh?
In the Utpal Kemprai, just now he realized, there is no review, only charge sheet is issued.
No, the review was there.
In that
Lordship.
case, I was appeared.
Hmm.
I considered that there no review was done, Lordship.
Review
If I
was
see
there,
that-
Lordship.
Here,
Here review is done.
review is done.
Utpal Kemprai review was there, Lordship.
And in this case, present case,
Review was done, Lordship.
since
far-
the charge sheet has already been done.
Charge sheet is done within 90 days.
So
Thereafter,
90
within 90 days, so review was also done, Lordship. That was communicated with the petitioner. That was, he has acknowledged this. We have filed our, in our affidavit, we have stated that he has acknowledged that. That part was done. Otherwise, Lordship, DP is in the verge of completion.
Lordship,
may-
observe note paragraph 22 of Utpal Kemprai. 22, Lordship.
The court notices the dispute proceeding instituted against the petitioner is on the verge of completion and order thereon is required to be passed by the signature after complying with mandate. What is disturbing the fact the inquiry report in the matter was so submitted by inquiry officer to the government in the review meeting. Hereafter for a long period of time, the same person had not taken. This is
Paragraph-
something, no, this is something different. We'll
Paragraph
consider-
18, Lordship, he says review was not done, it says review was done. Paragraph 18.
On review, the period of suspension was being extended. The subsequent reviews carried out in the matter of order of suspension considered view of this scope would be of no concern as much as it is demanded.
Not within 90 days.
And the order accelerated must be served upon the petitioner along with the so-called notice be served upon him submit to the date on which notice was served.
That is my case, Lordship.
No, here, it was not reviewed.
Not,
It was reviewed, Lordship, it says. 18 says it was reviewed.
no,
No,
not.
no, in terms of the Honorable Supreme Court.
Yes, in terms of that, it was not reviewed.
Your
Along
case,
with the
your
show cause.
case, your case, they said, when it, after the, charge sheet, review was passed with reason which was communicated to you.
Which
That
was
is what
not
it is.
communicated to me, Lordship. That communication is again a point of dispute, Lordship. But Lordship, the
Actual
paragraph 18, the sum and substance is, when the show cause notice was served, extension order was not there, even proximate to that date of the service of show cause notice, the extension was not there.
Yes, that is what you are, yes, you saw us, that it was done with reason orders. Yes.
The Lordship, before going to the Lordship, if you dates Lordship, we take
Yes.
note, Lordship. Date of arrest of the petitioner was 7/2/2024. 24.
24,
Lordship. No, 7/2/2024. 12th of
7,
February, yes.
7/2/2024.
Thereafter
That-
he was suspended from service on the day itself, 7/2/2024.
Yes,
He was arrested, sorry, thereafter he was released on bail 6/3/2024.
6,
3/2024.
yes,
Thereafter, he intimated to the department on 19/3/2024 that he has been released on bail. 19/3/2024, intimated to the department.
hmm,
Thereafter, show cause notice issued 27/3/2024. Show cause notice
so cause
issued on
20,
27/3/2024.
yes,
Show cause reply he submitted 10/4/2024.
yes,
Thereafter, suspension order was reviewed on 10/5/2024. First order also.
on,
First order was 10/5/2024. Thereafter, 2-3 days it is
10/5/20,
24.
so,
That's it. Now let's see. If we go by the date of intimation, 19/3/2024, he has informed to the department
it will be from the date
on
of,
the date of intimation. That's it.
Hmm.
The rough head area, that's it. That's it. No, that's it.
so within 3 months, 90 days.
90 days. That's it. Good proceed.
Yes, then,
Then let's see. Now let's see. We have filed an affidavit. Affidavit. Para 10 we have stated. Page 50.
affidavit of,
Affidavit of respondent number 2. Start from page 47.
yes,
Para 10, what's it? Page 50.
hmm,
With regard to the statement made in paragraph 10 and 11 of the writ petition, the deponent respectfully states that
Reviewed
the
and
order of suspension was reviewed and extended periodically. As per the record, after issuance of suspension order dated 7/2/2024, right order dated 10/5/2024, the suspension order of the petitioner was reviewed and the same is extended until further order. Thereafter, by order dated 7/8/2024, the respondent authority has again reviewed and extended the suspension order until further order. And lastly, by order dated 18/11/2024, the respondent authority has again reviewed and extended the suspension order of the petitioner until further order. Further, the deponent respectfully stated that the proceedings of the departmental inquiry has already been completed and the inquiry report is being prepared by the inquiry committee. Now let's see. The first suspension order, Lordship, page
it's okay. Then what about this after the charge sheet? Charge sheet was 27/3.
Lordship.
Then the assembly proceedings has already been initiated with time and assembly.
Alice. The petitioner has claimed that no reason has been given in the extension order, Lordship.
Hmm.
The kindly see the page 57, annexure C of the order. The reason has been given, Lordship.
57.
First, second, third paragraph.
Hmm.
Whereas it is observed that the charges for which delinquent official was placed under suspension are grave, and if the delinquent official is reinstated to the work, there is every likelihood that his presence at the workplace will vitiate the working environment of in the office. Therefore, considering smooth completion of the departmental proceeding, that undersigned extended the suspension period of Arafat Alombra, that is the petitioner, land record assistant, Vishwanath, until further order. This is the reason, Lordship. Otherwise, Lordship, that since the inquiry has been completed, Lordship may dispose of the petition with a direction to the respondent authority to complete the EP within time frame, Lordship. That would be beneficial for maybe for the petitioner also, Lordship. Without interfering the suspension order.
What is the order after charge sheet?
Lordship.
What is the order of the
Extension.
review?
Review, Lordship.
Extension, sorry,
Lordship.
extension.
Page 57,
After
Lordship.
this is after the charge sheet.
Lordship.
Placed under
49.
suspension in subsequent to arrest so and so in connection with what is the permanent prison initiated by so and so. Subsequent they received a GPM memo from director of the investigation and is in progress where it is observed that the response. Ten, 10-6, 10-5.
10-5.
Charge sheet was submitted. Memorandum?
27-3.
27-3, Lordship. Page 54 and 55.
54.
Yes, sir.
Hmm. Twenty-seven three. But extension what 10-0, 1-0.
First was 10-5.
Huh?
First was extension was 10-5,
Hmm.
then 7-8, then 18-11, and lastly in the month of November it was extended. This is not in the record. Otherwise, Lordship, if we go by the facts of the Ajoy Chaudhary, para 22 there, the honorable court did not set aside or interfere the suspension of the Ajoy Chaudhary. That particular case, Lordship. Since the charge sheet has already been filed and DP was initiated, Lordship.
So you have completed the DP.
So I have completed some due to some lapses that time has been take to be completed the DP to take a decision, Lordship. Within the time frame, Lordship made the action.
Just to point
Completed.
it out to your lordship, on the last date, lordship, the facts were reproduced before the
Other-
cabinet bench. And Mr. J. Henrik had submitted that some time may be required. And this honorable court had directed that if it is not completed on or before 2011, I will interfere with the suspension order. Saying so, the time was 5 days.
This was
Though the court was
view.
not inclined to grant time, still on their request, this 5 days time was granted to them.
5 days it was possible. Lordship, the civil
Lordship,
application,
it is
Lordship,
not 5 days, it is 22 months from the date of suspension. And January 25, their own
similar
affidavit.
situation, Lordship.
11 months from their own affidavit, lordship. They have completed the DP, they don't issue the order.
But the prolonged DP is not the issue, Lordship. Issue here is, Lordship, the suspension and the review, Lordship.
On the charges, that the charges are grave. Lordship have yourself observed in your order, lordship, that principles of human dignity need to be preserved, and however grave the charges are, one should be reinstated. If the inquiry is completed, what keeps me away from my service, lordship?
Para 7 onwards, Your Lordship, it will be. 24. In fact, our office memorandum says review has to be done within 6 months, Lordship. Charge sheet has to be within 90 days, but review has to be done within. On the basis of this order, OM, the schedule number for that's now given order of pass. This should be.
Office memorandum, second para will be relevant, Lordship.
Oh, yes, sir. Next question.
You have a separate office memorandum.
No, it is the same one, Lordship.
Huh?
4/2/2020, Lordship, 4th of February. Second para says along with the charge sheet, first extension, and then fifth para says after that subsequent extensions within 6 months. For further continue, it says, fifth para. Fourth para, Lordship, sorry.
Yeah, note.
That Utpal Kemprai, Lordship, paragraph 14 to 18 is exactly similar.
We'll
I
see.
rely upon.
X are different.
Just one point, here for the district commissioner here. Just as our learned friend was saying that charge sheet has to be served along with the extension order, that is not the case. The language of this particular paragraph number 2 says that if the memorandum of charges is served within 3 months of suspension, a reason order must be passed for the extension of the suspension wherever necessary. Not along with that
Which one?
OM.
OM, of the OM, not along with the charge sheet.
OM of
Independent.
Assam OM.
Yes,
Assam
yes.
government.
The person department.
Heard Mr. This sir of learned counsel for the petitioner. And also heard Mr.
As doctor.
as the standing counsel,
This is also revenue department.
revenue department,
Or respondent number 1 and 2.
1 and 2, and Mr. D. Bora, non-state counsel for respondent number 3. Next. challenges. Made in this petition is to the order of suspension dated 07/02/2024, passed by the. Where's the suspension order?
Page 18, Lordship.
Deputy Commissioner, Vishwanath. Where the petitioner. Whereby the petitioner was placed under suspension in connection with the Vigilance and Anti-Corruption, come on, Assam case number ACB PS case number 14 of 2024 under section 7, page 18. And for a direction to reinstate the petitioner. On the ground that the suspension, on the ground that even after filing submission of charge sheet oblique charges oblique of course so cause notice the petitioner has been placed under suspension placed under continued to place under long suspension without passing a reason order extending the period of suspension of the petitioner. What's the order? Chamber.
Obliged, Lordship.
Chamber. 9, 10, 10, 9 and 10 because of. Supplementary. Yes.
May I please, Your Lordship? Well, this matter is relating to provincialization of service of grade 4 employee in an elementary school. If Your Lordship kindly come to page
Thank
19.
you. File the affidavit.
Time to file affidavit, my lord.
Affidavit will be required.
Several occasions.
Huh?
Lordship, short date may be given earlier several occasions, sir. Time.
Not several occasions. It's two
25 matters, my lord. After 3 weeks, my lord. In the meantime, I will file affidavit.
affidavit will be required.
This specific date may be given, Lordship.
Not Mr. M. Hussain.
M.
M. Khan, sorry, Land Council for the petitioner. Next para. On the prayer of Ms.
S. Sutia.
S. Shutia, Landed Standing Council.
Elementary.
Elementary Education Department. Further 3 weeks time is granted to file affidavit in opposition. Just after 3 weeks.
Here, Your Lordship, make,
What is the part-heard matter?
a partner.
Huh? Part-heard matter. Take it up, part.
Lordship, if Your Lordship, there's a very small issue on item number 11. It came up on last date on 17th, wherein 2 days time was granted to file affidavit. Actually, we could have filed it yesterday itself, but since we could not serve the copy upon the petitioner yesterday, my clerk had been actually trying to call up his number, but he was not picking up the phone, so we could not serve upon him yesterday. So now perhaps he has been served a copy of the affidavit. So we'll file it today. Just now he had been served. So
You have
we'll file
filed?
it. We'll file it now only, after serving him. So
Heard Mr. So-and-so, Land Council for the petitioner. Next para, Mr.
Devora.
Devora, London State Council submits that although the affidavits as directed on, as directed to be filed by an order dated 17/11/2025 was ready for filing, comma, due to inability to serve the copy of the affidavit to the land council for the petitioner. Despite best effort, comma, same could not be filed yesterday. Step D4. No, Mr. He submits that the affidavit as required would be filing during the course of the day, a copy of which has been served to the then council petitioner, which has been acknowledged. Mr. Considering about, let the matter be listed on.
If they want to file any reply to the affidavit, yeah.
Be above. Consider above, comma, the Learned State Council is granted to, is allowed to file the affidavit today, huh?
Yes.
Today.
Yes.
What do you want?
Got it.
You want some
We have got
reply?
it, Lordship, now,
You want to file some reply?
yes, we can let it be fees for admission.
As,
We have none.
as agreed to by Land Council for the parties, let this matter be listed after 2 weeks,
That's it.
after 2 weeks.
Authorized.
Lord, government has already done their part. He was supposed to mail it. Yeah, appeared on the last petition. Then.
Where is? See, after some time.
Wait, reservation. The petitioner claiming for the fixed wages limit, which was subsequently rejected by the Commissioner PNR developed, and the said order has been challenged.
Lordship, we have received an instruction wherein it is stated that the proposal in regards to the petitioner has been forwarded from the CEO to the commissionerate level. The commissionerate is at present waiting for certain other proposals from certain other districts. Once those comes, then all those proposals will be verified and then it will be forwarded to the government. So it will take some time, for some time.
2014 matter.
Yes.
Lordship, his name has.
Can we dispose of?
Yes.
Seeing
Can be,
that,
well, can
it's-
be
it's a-
disposed of
It's a matter
on the basis, yes, on the basis of an direction may be given. That
to
within,
consider and.
yes, consider his case within a period of pursuant to their instruction. In fact, matlab he is entitled, recently matlab his name has been forwarded.
No, Roshan.
He is otherwise entitled. matlab. Malad, initially what had happened, the direction was given from by this honorable court. And pursuant to that direction, where it was hearing was taken place in the commission. And in that hearing, Malad, first
So I
time-
will not go into all this thing now. All right.
yes,
If you agree, we'll close the matter with direction to consider your case
yes,
in terms of this, this thing. All right.
yes.
The verification, Lordship.
But ultimately, if again further verification again rejected, then problem will created, Malad. Because once they have rejected.
No, see, have you clarified how much you are getting now?
Now, Malad, 14,000.
Hmm?
Now 14,000 I have already brought on record, Malad. Can you see?
You are getting 14,000 now.
Yes, now.
And Mr.
Aris.
R. Islam,
Yes.
learned counsel for the petitioner. And Mr. So-and-so, learned.
A.K. Ghosh on behalf of Mr. K. Kumar.
Huh?
A.K. Ghosh on behalf of Mr. K. Kumar.
K. Learned. Standing counsel PNRD,
Lordship, that would be additional easy.
Additional Advocate General, appearing for
All the responses.
state respondent. You are working as
Working as one a casual worker in
Night
Sorong
chau-
Jila Panchayat.
night chowkidar.
Yes.
Night chowkidar.
Not net Chokidar, but now the Chokidar.
Huh?
Chokidar, initially appointed as net Chokidar.
Next matter, the petitioner. Next matter, no. Just a minute. The no, this present petition is instituted by the petitioner claiming for a fixed pay payable to the casual workers of the PNRD department in terms of the communication dated 25/01/2012 of the Joint Secretary to the Government of Assam in PNRD department, which provides that, please, they said communication provides that casual workers who were engaged in different Jila Parishads, Anchalik Panchayats and Gai Panchayat prior to 01/04/1993. And after 01/04/1993 up to 31/03/2006 would be paid a fixed salary of rupees 4,500 per month. The petitioner claims that he was appointed as casual worker in Darang
Dorong Jilla Parishad,
Jilla Parishad as Chokidar,
Chokidar.
night Chokidar
Yes, sir.
initially,
Initially not Chokidar,
now Chokidar.
now Chokidar.
Now, casual worker within bracket, huh? Chokidar. Bracket close. In Darang Jilla Parishad on 01/09/2005, and therefore he is entitled to fixed salary dated 25/01/2012.
Malad?
You want that as per the communication, you should be paid this fixed salary.
Yes.
Next paragraph. Mr. So-and-so Learned Council. Where it is? Where's the instruction?
Actually, I placed it.
611.
Yes.
So-and-so Learned Council appearing on web so-and-so for the state respondents. While placing the copy of the instruction oblique communication dated 06/11/2025, submits that. The chief executive officers of Jilla Parishads were requested to furnish detailed information with regard to the what is this AFRBM?
Assam,
Malad, AFRM Assam Fiscal Responsibility and Budget Management Act.
What act?
Malad, after, as per this act, Malad, this the fixed salary has been
Detailed
provided.
information with regard to genuine pre-AFRBM and High Court related case, casual worker employee as per the Finance Department prescribed format list of accordingly the CEO, Darang Jilla Parishad by this letter dated 15/10/2025 has forwarded the requested information regarding pre-AFRBM and post-AFRBM. I just wanted to know what is the AFRBM?
Malad, this is an act, Malad. The AFRBM means Malad Assam Fiscal Responsibility and Budget Management Act.
Okay.
That is prior to and after.
Pre-AFRBM and post-AFRBM casual employees in respect of 9 casual workers, including the petitioner hearing. Therefore, the verification and scrutiny of the proposal received from the districts are underway. And some proposals from other districts are yet to be received. And once it is completed, the proposal shall be sent to the government for further consideration. Next paragraph. Having considered that the respondent authorities are, in that case, we'll record your name.
Yes.
Because we are
Yes, sir.
disposing of the matter.
Yes, sir.
Having considered that the claim of the petitioners, along with the other similarly situated persons for providing of fixed pay
Fixed.
in terms of the government policy, we'll say
Yes,
policy.
yes, government policy.
It's a government policy only,
Yes.
is not it?
Your lordship, the, his annexer 5, your
It
lordship.
is a government policy, my lord.
Government policy.
Government policy.
Yes.
Your lordship, he is claiming enhanced pay of rupees 4,500.
That wave record, we're not passing any, this thing, issuing any mandamus. We'll
Yes.
just say that you consider and
Yes, yes, yes.
within time frame, you will have to consider, right?
Right.
As per the government, is this a payment is government policy only?
Yes, yes, my
Yes, yes, yes.
As per the government, relevant government policy. And as agreed to by learned council for the parties, I deem it appropriate to dispose of this writ petition. Mr. The dispose of the writ petition with a direction to the responding authorities to consider the case of the petitioner along with other similarly casual workers in terms of the relevant government policy for providing fixed salary,
Yes.
fixed wages or fixed salary.
Fixed wages, my lord.
Fix wages, your lordship.
Fixed wages.
Instead of salary, fixed wages, huh? Within a within time frame, this stuff. Accordingly, it is directed. Accordingly, this writ petition is disposed of with a direction to the responding authorities to consider the grievances of the petitioner along with other similarly situated persons in terms of the relevant government policy. For providing fixed wages to the casual employees, casual workers, huh?
Yes.
Yes, your lordship.
Within a period of 4 months.
4 months.
4 months from today. Mr. That's all.
Yes.
Send disposal. Extensions for them.
Much appreciated. Oblige, your lordship.
Thirty. Yes.
My lord,
I-
before my friend starts, my lord, just I want to inform that, my lord. Government, our part, my lord, my friend Dinath has already argued the matter, my lord. Today he is not here, my lord. But I'll be here, my lord. If anything has to be, my lord, has to be made, my lord, from our side, my lord, we'll seek another date. He is indisposed because he is out of town for a medical treatment, my lord.
My lord, I am sorry, my lord, when the matter was called for, my lord, I was on.
No, it's okay.
My lord. My lord, actually, the hearing is almost, I have done my part also, my lord, regarding that whether the government can issue the order or not, my lord. And in that aspect of the matter, my lord can close the hearing and can fix the problem.
Then unnecessary, why we're getting it?
No, my
fixed
lord,
one
what has
after
happened, my
another?
lord?
This submission could have made day for
My lord,
yesterday
my lord, I
also.
have, no, my lord, I have searched the few judgments, my lord.
Nothing.
Those
Except for this judgment which you have placed, there's nothing.
No, there are 3 judgments, my lord, which I am going to give it to learned court master by tomorrow morning, my lord.
No.
My lord,
What
can,
for? What judgment unnecessary? What
no,
burdening the
no,
judgment?
no, my lord, the judgment which I have find out, my lord, is regarding the issue that whether the government can even constitute the managing committee, because here is a, my lord, mosque, and inside a mosque, there is also a religious educational institution, my lord. So in that line, my lord, few judgments are there, my lord.
Okay. This is basically fixed for that only today.
Yes, yes, to deliver the judgments, my lord. By tomorrow I can give, because my learned
Not
colleague, my
deliver,
lord,
to place the judgment.
my lord,
to place the judgment.
My lord, my lord. No, no, my lord can close the.
Yes.
hearing, my lord.
What do you say?
My lord.
Did I hear you? Did I hear you last occasion?
Last occasion, Lordship, he had, but not completely heard, Lordship.
What do you want to say? Any judgment you would like to rely?
Judgment, Lordship,
Yeah, you are a kind of entrepreneur.
no, Lordship, actually, what happened, Lordship, I am
Who are
the,
you?
I am the president of All Assam Goriamura Deshi Jatiya Parishad. I mean, the indigenous Muslim organization, All Assam level.
What is your-
I am the president of district committee. So I organized a demonstration before the Panbari Mosque for its maladministration and corruption happening in the management of the Panbari Mosque. So under my lordship,
At
when
your
I-
behest only this committee, new committee was considered, this order was passed.
this order was passed,
Impugn order was passed.
impugned order was passed.
How you are interested? How you are affected?
I am affected, lordship, as because the,
See, matter is very simple. What they are saying is, we are also the what do we call it? Follower or something like that.
My
Where
lord.
what do you call it?
The committee, my lord.
No, what?
The Jamaat,
Huh?
the nearby, the surrounding of the
You are
mosque,
the members of the Muslim community.
Muslim community.
Nearby this
My lord, our
this,
first.
masjid,
also
who
lordship,
is also having
No, no,
a,
my lord, my learned friend's submission is that as they being the indigenous Muslim, so therefore they are eligible to be the part in the my lord, management committee. As we are not indigenous Muslims, so therefore we are not eligible to be.
that is
included.
their stand.
That is
No,
their stand.
no, my lordship, my learned brother is wrong in his submission. This is not my, this is not the exact submission of.
No,
My submission,
see,
lordship.
his case is number one.
Hmm.
He's also a member of the Muslim community. He's a Muslim. He has a equal right, and is stakeholder of the masjid,
Lordship, here.
right?
Lordship,
Now, this is a religious, a private institution which has to manage by the community. Why you have only picked up to be for the committee or for the management of only 7 villages? Why not 27 villages?
Coming to that point, lordship.
That is, they are agreed. They want to be the part of equal, they want to have a equal
Exactly,
share
exactly.
in the management of the committee.
Lordship,
I mean, the masjid.
lordship.
Yes.
So there is a rationale of selecting of these 7 villages
Yes.
for constitution of the management committee of the masjid.
Yes.
There is a historical background behind this.
Yes.
Historical background, lordship, when during the late 15th century, that mosque was built up by the Hussain Shah of
We've seen.
Bengal. So at the time of building of that mosque, the management and control of that mosque was entrusted to the indigenous Muslim people inhabited there. So from that point of time,
So
lordship,
therefore,
kindly-
these 7 villages
yes, lordship,
are
these 7
only,
villages,
what do we call it? What Muslim?
Deshi Muslim or converted coast Muslim.
Ah,
So the president of the those
Desi
Muslims,
Muslim. So it has to be managed by
Deshi Muslim,
Desi Muslim.
and
And the petitioners are
they are immigrant Muslim,
immigrant Muslim.
immigrant Muslim.
Who is not,
They are not inhabited.
doesn't
Their existence come only after the Assam State Acquisition of Sealing Act came into play, and out
Now,
because of that Sealing Act.
they cannot be a member of the management committee. According to you, they cannot be a member of the management committee.
Lordship, this is not my submission. My submission is that the 7 villages predominantly inhabited by the indigenous coast Muslim or Deshi Muslim, they used to administer that.
That's
mosque.
why I'm saying, they are claiming they are also entitled to be the part of the management. According to you, since they are a immigrant Muslim, they don't have a right to
No,
be
they have right to allow, they have right to pray, offer their prayer, they have right to.
not
look
the
after
right to
management.
management.
Management lordship from the very beginning, we people are continuing with the management of the masjid.
Indirectly, what you are trying to say indirectly that they are not be entitled to be part of the management. They can access to the masjid, they can have the prayer and other things.
Everything they can do. But
Any facilities they can enjoy.
every.
But so far as the management is
Management is
concerned,
concerned.
it is only by the, what is called, Desi,
Deshi Muslim.
inside or Desi,
Deshi or converted.
Desi Muslim, or
Yes.
Desi or converted Muslim.
Lordship.
In view of the historical fact,
Historical background, that is.
background and facts,
This is already in record.
which all been managed by these people
These
only,
people, lordship.
from the 7 villages,
For 7
not,
villages.
not from other
Not from
villages,
other.
who are the migrants,
Migrants.
Muslims.
Muslim.
That's
And
all.
this fact, lordship, has been recorded in the first ever census carried out by the British government during
Yes,
the year
but-
1872. And
Okay.
that has been published during the year 1879 by W. Hunter. It has clearly been recorded in that
Seen it.
lordship.
The we have heard it from the senior government advocate on the last other day.
This is
Okay.
my submission.
That's a submission. Very simple. Your submission is very simple.
And so far my learned brother is taking the plea of educational institution that cannot be interfered with. This is what my learned, this is how this.
So now there is no problem, no issue.
No,
it's
education,
peaceful.
minority status of
No,
the
no,
education
it's
is not.
peaceful now.
Huh?
It is peaceful now.
It's peaceful.
Everybody is allowed to
Yes, yes.
access to the
Yes.
masjid.
Yes.
Yes. Maintain,
Everybody
maintain
has the
peace.
access.
Don't discriminate within yourself. What is inside migrant? Once Muslim is always a Muslim.
Lordship, this is, we don't have any hatred or any enmity with them. We are brothers. But thing is that from the history, from the very beginning, we people are administering the masjid. So how can
Unless
be
you are-
deprived?
Unless you are converted. Okay, heard Mr. Air Buya. Heard Mr. Air Buya, Learns Council for the petitioners, and also heard Mr. We'll record his name. The Nath, Learned Senior Government Advocate, are there Learned Standing Council. Standing Council, Additional Senior Government Advocate, as well as
Islam.
Islam for
Respond number 6.
Islam for responding 1, 2, 5, and Islam for respond number 6. Anybody else? No. Judgment, hearing ultimately concluded, judgment reserved.
Fine. Deeply obliged.
Obliged.
Rakesh Barua.
So, my lord, last occasion, the court has directed to file an additional affidavit, my lord, which has already been prepared and sent for vetting, my lord. So after 1 week, it may be.
Or MS so and so learned counsel for the petitioner. Although matter is fixed for, matter is listed for hearing. MS so and so
A. Bora,
learned,
Standing Council, and
A. Bora, learned counsel, standing counsel,
NHM.
NHM. Submits that she may be granted some time to file additional affidavits as directed by this court. List of considering it. Let this matter be listed after. No, not considering as prayer for granting time to file additional affidavit is not objected to by learned counsel for the petition from us, same is granted. Stuff accordingly list this matter after
1 week.
after 2 weeks. 2 weeks.
Please, your lordship, senior counsel is on legs. So matter may be passed over for time being.
Possible. Yes. Item 20. Respondents.
Yes, lordship, we have received the records, lordship, of the departmental proceedings.
None appears for the. It is submitted by MS.
U Sharma,
U. Sharma.
for all respondents,
Learned,
junior government advocate.
listed counsel submits the seals. Already received the records.
Anupam,
20.
my lord, I am appealing for the petitioner. My lord, this matter may be passed over for today, my lord.
Not today.
For today, lordship.
Then in this case, is this on the prayer of first, on the prayer of so and so, learn the counsel for list this matter after 3 weeks, huh?
Lordship.
Then you write. MS so and so submits that. And so. She has already received the records. 3 weeks.
Much obliged, lordship.
Yes.
Basically, also, this is pertaining to a outcome of a disciplinary process where the petition was been dismissed for service. He was, lordship, basically, that allegation was in regard to misconduct, lordship, there was a trap. And he was being part of a criminal conspiracy, taking bribery. So, lordship, so
It's
far
okay.
has been also,
Who is there?
I think B. Chakraborty name is being shown in the side of the petition.
None appears for the petition on call, comma. Mr. So and so, learned counsel, state counsel is present. List the matter after 3 weeks.
Most of those.
Kindly pass over for time being. Mr. B. Pathak is on legs.
Pass over.
Item number 26, my lord. Miss MD Bora, she had to leave the court due to some personal difficulty, my lord.
Which for the petition?
I am not. He's for the petition, my lord. Some accommodation. my lord.
It is submitted by
Hardly
Mr.
goes on.
So-and-so learned counsel appearing on behalf of Mr.
Miss MD Bora.
MS NB,
MD, my lord.
MD Bora, learned standing counsel
Corporation Department.
who had to what I said, appearing for so and so submits that MS Bora had to leave the court premises due to personal. And this is a personal problem.
Yes, sir.
Request for listing of the matter after
Lordship, kindly next week, if possible.
after a week.
2 weeks, my lord.
Kindly, Lordship, date may be given.
As the and, Mr. So and so learned counsel for the petitioner is present. Accordingly, list this matter after a week.
Obliged.
Obliged.
Item 23, Lordship.
Ah,
My senior, he was engaged in port number 10, Lordship.
it's all. Well,
Sir.
see,
So give us some 1 day, Lordship.
after a week,
After,
3 weeks,
Lordship, after a week,
2
Lordship.
weeks, 2 weeks.
Doesn't-
Make it 2 weeks. Item 23. Yes.
Lord, in late 2000, and early 2001, under Operation Blackboard, my lord, about 7,066 teachers were appointed. Now we are concerned with appointment in Nalbari district. You know what had happened, my lord? There were 135 upper primary posts and 280 lower primary posts. However, my lord, what had happened, as against this limited number, that is about 15 my lord, about 4,000 appointments were made. Now, therefore, my lord, initially the move was that if it is possible, then we should identify the genuine appointees and the excess appointees should be, removed. My lord, that matter continued, even though, my lord, the actual select list was retrieved because it was seized at that point of time. And then, my lord, it was sent for forensic examination and all. Yet, my lord, state just behaving like an ostrich, they are refusing to, recognize the reality. Now, the first order which was passed by this honorable court, which your lordships will get at page number 144. It starts at 144. And if your lordships would kindly come to page 156. Oh, my lord, kindly have the paper book of WPC 5627 LP.
Sure.
One is LP, other is upper primary. Yes. Please come to page 156, para 14. This was a judgment rendered on, my lord, 4th of December 2001.
Yes.
In view of what is stated above, this court considers that it would be appropriate to dispose of the writ petitions with a direction to the state government, initiate an inquiry forthwith to be completed within 15th of January 2002 in order to determine the genuine select list referred to above and identify the candidates who were genuinely selected and allow them to join their respective school as per the appointment letter issued earlier and cancelled by the impugn orders. So order was very clear, my lord. Please conduct an inquiry, identify the genuine appointees and then appoint them, and whosoever has been excess appointment, cancel their appointment. My lord, this was followed by, my lord, several appointments, my lord. Eventually, if your lordship will kindly come to page number 178.
Yes.
Yes. Now kindly see, my lord, under Right to Information Act, this application was made. Submission of list of 1 year appointed OBB teachers in LP school on March 2001, along with information thereof. Under the subject cited above, I have the honor to inform you that documents related with appointment of LP school during March 2001 have been seized by the then DC, and the office file also submitted to you on 11/11/2009. However, records of photocopy available in the office. 280 number of teachers were appointed constituency-wise as per the list submitted by Subdivisional Elementary Education Advisory Board, Nalbari, both BSc and general area against the 280 number of allotted posts. The list of 280 number of teachers are enclosed here. Further, the then DIF school Nalbari, G. N. Halloy appointed some excess teachers against non-existing posts which are received from the person concerned are also submitted to you for your kind consideration. The report of 280 number of teachers and excess teachers have already been informed to you, and Kamal Das, son of Sri Maheshwar Das, RTA petitioner, by this office letter dated so and so. So I would like to request you kindly to withdraw the cancellation order in respect of 280 number of genuine teachers as well as the excess teachers from your end after comparing the original records which are in your custody. So the matter is absolutely clear. There is no ambiguity. So, my lord, the Deputy Inspector of School requests the director that yes, against 280 number of posts, excess appointments were made. However, they could retrieve the record which was seized by the Office of the Deputy Commissioner, and from where it appears that G.N. Haloy, the then Deputy Inspector, he made excess appointment, and now therefore the director should take a call on which all are the, my lord, the entire list is given at from page 179. I may just indicate, my lord, serial number 21 is petitioner number 6. Serial number 21 is petitioner number 6.
Yes.
Then, my lord, at page number 181, serial number 53 is petitioner number 2. Then at page number 183, my lord, serial number 104 is petitioner number 5. Page 183, serial number 104 is petitioner number 5. Then, my lord, at page number 184, serial number 112 is petitioner number 3. Then, my lord, at page number 186 on top 146 is Pulak Majumdar, petitioner number 1. And page 187, my lord, serial number 162, petitioner number 7. Then page number 188, my lord, serial number 170 is petitioner number 8. And then at page 192, my lord, serial number 247 is Buddheswar Ramsiari, petitioner number 2. So these are the 8 petitioners before your lordship.
9 or 8?
8, my lord.
Yes.
Yes. My lord, things were going on. My lord, there are so many other facts which are not really necessary. Then, my lord, will kindly come to page 195. This is also a letter information under RTI, my lord.
So this is LP.
This is LP, my lord.
LP is for five petitioners.
No, my lord, before your lordship, there are 8 petitioners today in this petition, and 280 is the select list. Oh, now there are 5. I'm sorry, there are 5. Oh, I'm sorry, my lord. In the earlier round of litigation, I'm sorry, there were 8, so I'm referring to 8. There are 5 petitioners.
Then here, this is ME.
The other one is ME.
Same process.
Same
selection.
Same. Then, my lord, kindly come to, my lord, page number 212. There were another round of inquiry.
Yes.
It starts at page 211, my lord. Inquiry report in connection with appointment of OBB teachers in Nalbari district. Appointed in the month of March 2001. My lord, will kindly come to page 212.
Suggestions.
Yes. No, findings, my lord. From the above facts and circumstances, it seems that though DIS, that is Deputy Inspector of Schools, submitted the original proceeding register and original approved list to the DEO Nalbari White letter dated 23/3/2001 as reported to the Director of Elementary Education by DIS Nalbari White letter dated 10/3/16, and Jotin Goswami, the then Senior Assistant Office of DEO Nalbari, handed over to Sri Paresh Sharma, Senior Assistant of the same office, on 30/11/2012. The matter was not brought to the notice of the DEO Nalbari on higher authority, even though he knows the sensitivity of the matter. Milord, now as if, Milord, because now the original records have been retrieved, it is a fault. It is a problem has arisen. Kindly see the attitude, Milord. Now, because why it was not there? Because it was seized by the Milord District Administration immediately. Then suggestion. The matter may kindly be brought to the notice of the government regarding genuineness of the proceeding register and approved select list as received by Paresh Sharma from Jotin Goswami, as because they kept silent regarding availability of the original proceeding register and original approved list in earlier inquiry as conducted by the inquiry committee constituted by the government from time to time. In this regard, government may also be requested to take necessary steps and issue instruction regarding genuineness of the proceeding register approved list submitted by DO Nalbari on 9/3/16. Then, Milord, will kindly see, since there was a controversy whether these are genuine or not, eventually, Milord, this Honorable Court, by an order at page number 221, Milord, referred the matter to the Milord, forensic laboratory. Please come to page 224, Milord. Please come to the last parameter at page 224. In view of the above, the correctness of the conclusion of Commissioner and Secretary that there is no way to ascertain the genuine appointee in respect of Nalbari district in respect of OBB teachers appointed in 2001 has to be verified. The respondents are directed to produce the original proceeding register, original select list, which is indicated in the order dated on the next date fixed. Then there was an order that produced the original record before the court. Subsequently, my lord, at page 229, kindly see. Now, this is very important, my lord. Page 229. In the course of hearing of the matter, it has come to the notice of this court that the particular record which should indicate the list of candidates who were selected and appointed at the relevant point of time is made available as of now. As the record was not available over the years, an apprehension arises has been raised as to the genuineness of the said record. For appropriate adjudication of the matter, it is deemed appropriate that Forensic Science Authority examine the record relating to select list and submit its report. So, my lord, since they were trying to behave like ostrich, though the records are there, they are not trying to recognize it or, my lord, give a deference to the record. Therefore, this honorable court said, let this be, vetted by the forensic expert. Then, my lord, will kindly see the next order at 17/9/18 at page 233. Last paragraph, my lord. The Director of Forensic Science Assam shall also show cause the aforesaid Sri Bapukon Chaudhary Junior Scientific as to why he had not complied with the requirement of this registry of this court to submit report on or before 25/8/18 or to hand over the case to the Deputy Director in charge by so and so. Anyway, this is not relevant. Now please come to, my lord, page 238. A report of the forensic authority is made available and Sharma Learned Standing Council for the Elementary Education prays for some time to peruse the report and make his submission. Prayer is allowed. As prima facie the report goes against the department, the registry may provide the copy of the report of the Learned Standing Council, Elementary Education as well as Learned Council for the petitioner for examination. Now, below the report is the next page. Now, this was addressed to the Registrar Judicial of the Guwahati High Court. Please find herewith enclosed report opinion dated so and so in connection with case number so and so. Now, please come to the next page, my lord, 240. Document in connection with WPC so and so received memo have been carefully and thoroughly examined with the help of different scientific instruments such as documents and docu center expert so and so under different lighting system. Physical examination and comparison of the list of selected candidates for the post of assistant teacher with list of candidates available in the proceeding register book reveals that out of the 15 number of sanctioned post of assistant teacher with the name of candidate for LP school, this is out of 280, my lord, this is the division constituency wise. For Borkhetri LSC, these are the, my lord, names. So and so of candidate with same names at present in the approved list. The name of the candidates. Now, my lord, this Nilokanto Medhi, he is petitioner number 3. Silent. Next to Paramananda Data Kiman. And next page, my lord, 241, serial number 45 is Paramananda Deka, petitioner number 5. Lohit Chandra Das. Then, my lord, at page 242, serial number 60, Lohit Chandra Das, his petitioner number 2. Serial number 60. Page 243, my lord, serial number 34. Now, the constituency is, my lord, Dharmapur. Serial number 34, Prakash Kakoti, petitioner number 4. Then, my lord, at page 244, Pulok Muzumdar, serial number 26 is petitioner number 1. So, what is more is required, my lord? They are not doing anything. Then, my lord, since they were doing nothing, my lord, we filed a writ petition that order lordships finds at page number 247 it starts. Please come to page 260. Same thing, my lord, they are repeating again and again. Page 260, para 11. I'll read from para 10, my lord, at page 260. Learned Standing Council Elementary Education Department, however, submits that reason can be ascertained from the second last para of the communication in which it has been mentioned that although the inquiry report of the Deputy Director has indicated about availability of certain documents, that is original proceeding register and original select list, this could not be considered to be genuine document. However, it has been contended on behalf of the petitioners that the said reason cannot be sustained as because proceeding register, original select list were made available as per back in the year 2003 as is evident from the letter dated 22/5/2003 from the District Elementary Education Officer Nalbari addressed to the Principal Secretary Education Department. This court, however, is of the opinion that in absence of any proper finding by the said committee, which was constituted by notification dated so and so, it would be premature at this stage to examine the rival claim of the party. Accordingly, for the reasons discussed above, the present petition is disposed of directing the respondent authorities to publish the report of the committee constituted by the notification that is so and so. And thereafter, the state government will take a reasoned decision on the basis of such report submitted by the aforesaid committee in terms of the direction issued by this court on 4/12/2001, the first case, and others, as these matters are pending for a long period, state government will do the needful in terms of the direction issued along with period of 3 months within the period of the date of receipt of the certified copy of this order. In this regard, petitioner shall be at liberty to submit all detailed representations to the committee, also stating the grounds and reasons in support of their claim, which shall be considered by the committee and the state government before making any final decision in this regard. It goes without saying that if there is a finding given by the constituted committee that present petitioners are among the genuine candidates who were recommended by this election, but they shall be considered for reinstatement, as has been done in case of other teachers under the OBB scheme who have been appointed subsequently in other districts. Similar dispute arose in other districts, my lord, it was done. Then again, my lord, at page 262, they are again and again the same very stand, my lord. Nothing new, which is the impugn order before this honorable court. At page 262, my lord, last para. This is the no minutes of the meeting of the committee. Very interestingly, this time the DO Nalbari and DIS Nalbari has submitted a copy of the proceeding book of the state level advisory board Nalbari along with the copy of the approved list of the candidate. After receipt of these documents, DE Assam has engaged Manoranjan Kakoti, the then deputy director, as inquiry officer to conduct hearing on the matter in order to find out genuinely selected candidates, if any. The inquiry committed by Manoranjan Kakoti had submitted their report where it was mentioned that the matter of appointment of OBE teacher in Nalbari district made during March 2001. Several inquiries are conducted from time to time in which DO Nalbari and DS Nalbari and the officials of their office have never mentioned about availability of the original proceedings, register and original select list in their place. In the report, it was clearly mentioned that though the above mentioned documents were submitted by the district level officer, yet these documents cannot be determined as genuine as the documents were reported not placed from time to time to the higher authority by the district official. Well, this is what was not said by Manoranjan Kakoti, but it is the view of this Pritam Soikia, the commissioner, my lord. Therefore, he comes to the same conclusion in the inquiry report. Now, my lord, wait, final. Then, my lord, based on this report, on 10th of June 2020, an order was passed. The relevant portion is at page 265. In view of the above, the committee constituted as per Honorable Guwahati High Court, dated so and so, has made the following observation. Out of 4510 candidates, it is difficult to ascertain which 280 candidates are genuine. On the basis of the report of the then Deputy Commissioner Nalbari, government issued instructions by order dated 4 July 2001 to DO Assam to cancel the appointment. Accordingly, District Elementary Education Office, Director Elementary Education issued cancellation order dated so and so, and the DEEO and DIS Nalbari cancel all the appointment. Further, more than 19 years have elapsed from the date of the selection of the states so and so, so and so. Major changes might have taken place with regard to the Right to Education Act 2009 regarding academic qualification as well as eligibility criteria for the appointment in so and so. Considering all these and above, the committee has recommended that claim grievance of the petitioners in contempt case number so and so, WPC number so and so cannot be considered. And my lord, their stand is there are documents, but these are old documents, will not rely. But forensic says otherwise. My lord, I am relying on 3 judgments, my lord. I am just handing over the copies, my lord, where the Honorable Supreme Court has said that if there are, please have first, my lord, 1991 FCC 411, paragraph 11.
1991 for SCC.
My lord, 1990, 1 SCC 411. Page 411. My lord.
Hmm.
Para 11.
Yes.
But give me 1 second, my lord.
Yes.
Yes. If your lordship would kindly come to page 421, my lord.
Hmm.
Line about 13 from bottom, my lord, of para 11 at page 421.
Hmm.
The sentence starting with, it is true that a candidate, has your lordship got it, my lord? It is true that a candidate does not get, has your lordship got it? Yes. It is true that a candidate does not get any right to the post by merely making an application for the same, but a right is created in his favor for being considered for the post in accordance with the terms and conditions of the advertisement and existing recruitment rules. If a candidate applies for a post in response to an advertisement issued by the Public Service Commission in accordance with the recruitment rules, he acquires a right to be considered for selection in accordance with the existing rule. This right cannot be affected by amendment of any rule unless amendment is so and so, etc. So, my lord, once a post is advertised, once if a incumbent makes an application, then he has a right of consideration. This is a judgment for that limited proposition. So I have a right of consideration. This right of consideration, my lord, it cannot be denied on some reasons which are not germane. Next, my lord, will kindly come to 1995 Supplementary 2 SCC 230, paragraph 10.
Yes.
Para 10. I am reading that sub-para. It is no doubt correct that a person on the select panel has no vested right to be appointed to the post for which he has been selected. He has a right to be considered for appointment. Now, this is important. But at the same time, the appointing authority cannot ignore the select list or decline to make appointment on its whims. When a person has been selected by the selection board and there is vacancy which can be offered to him, keeping in view his merit position, then ordinarily there is no justification to ignore him for appointment. There has to be a justifiable reasons to decline to appoint a person who is on the select panel. So, my lord, once a person's name appears in the select list and there are vacancies, then he has a right to be considered for appointment. Then the last decision, my lord, this Purushottam's case, 1999 6 SCC 49, paragraph 4. Uh, 1999
Yes.
6 SCC 49, para 4, at page 51. In view of the rival submission, the question that arises for consideration is whether a duly selected person for being appointed and illegally kept out of employment on account of untenable decision on the part of the employer can be denied the said appointment on the ground that the panel has expired in the meantime. We find sufficient force in the contention of Mr. Deshpande appearing for the appellant inasmuch as there is no dispute that the appellants were duly selected and was entitled to be appointed to the post, but for the illegal decision of the screening committee, which decision in the meantime has been reversed by the High Court, and that decision of the High Court has reached its finality. The right of the appellant to be appointed against the post to which he has been selected cannot be taken away on the pretext that the panel has in the meantime expired and post has already been filled up by somebody else. Usurpation of the post by somebody else is not on account of any defect on the part of the appellant, but on an erroneous decision of the employer himself. In that view of the matter, appellant's right to be appointed to the post has been illegally taken away by the employer. We therefore set aside the impugn order and judgment of the High Court and direct the Maharashtra State Electricity Board to appoint the appellant to the post for which they have been duly selected within 2 months from today. So therefore, to summarize my argument, my lord,
Yes.
it's a clear-cut case, my lord. Yes. If we look at the first judgment of 2001, where the direction was very specific. Yes, there are excess appointments, but please find out the genuine appointees. If the grain can be separated from the chaff, if the chaff can be separated from the grain, please do it and appoint the genuinely selected candidate. Now, admittedly, my lord, at different point of time, they were always taking this stand that it is not possible. Eventually, this honorable court referred the matter to the Forensic Science Laboratory, and Forensic Science Laboratory has said, no, this is a genuine selection. So therefore, I am claiming my right to appointment. But kindly see from 2001 till date, and Lordship knows how difficult it is to get public employment.
24 years. 24
And
years.
my lord, we are appointed. Now we are to be reinstated. We are appointed, our appointments were cancelled.
After 24 years.
24 years.
Where are you now?
My lord, somehow we are meeting our both ends meet, my lord. In that view of the matter, I'll humbly submit, my lord.
The same order, this
The same.
item?
Same.
And
That is upper primary, this is lower primary.
The impugn order is also same
Same order, but a different order in case of them.
and different writ petition.
Different.
The direction was also, there was a separate
Common,
writ
common.
petition.
Common order.
The impugn order is common.
And the first direction also common. We can argument have given in both the cases.
Yes, sir.
Yes, my lord. Right. But admittedly, my lord, there were excess appointment. Against my lord, 135 upper primary school teacher post. Total was appointed, my lord, 419 persons were appointed against 135 in case of upper primary, and in case of lower primary, my lord, against 280 number of posts, my lord, 4,510 persons were appointed. So, my lord, when it was detected that there were excess appointment, then, my lord, cancellation order was issued in the year 2001. Thereafter, my lord, they approached this honorable court, and this honorable court directed to find out the genuine appointee. But due to lack of original record, we could not ascertain. That will, my lord, will find page 217. This is a report from the Commissioner and Secretary to the Standing
Beyond
Council.
that, you have traveled beyond that.
Yes, my lord.
Thereafter, the records were produced before this court. It was sent to forensic. There's a report submitted here.
But
It was directed to consider.
But only thing is, my lord, though the
Now
records,
you are, now finally what you have said is that in view of a change of the act and rules
yes,
regarding qualification, eligibility, and after 90 years.
and 19 years,
This cannot be.
19 years, and right.
And the other
today-
reasons which you have, that has been considered in all the earlier proceedings. Finally, the things will have to be considered from the forensic report. All right,
Yes,
forensic report indicates, subject to what you say, that it has been as of now projected that they are genuine appointees. Forensic report.
yes, my lord.
That too not by you only, by the direction of this court only. Intervention of this court only. It was said, placed here, accordingly you were directed with the the intent was to consider it because you have segregated, or you have, find out the when you came to know the record, when record was retrieved or whatever, found back.
Basically, the record was not there, my lord.
Yes, then ultimately record was found. Is that it?
In fact, my lord, in
Maybe
the
somebody
earlier,
found it, retrieve or whatever.
in earlier inquiry, my lord, the district office, they did not submit the record to the
Now
inquiry committee.
thereafter, they have submitted the record. On
Subsequently-
the basis of that, there was a, whether the genuine, whether they genuinely selected or not, was sent to forensic at the, I mean, intervention of this court was placed here accordingly, you are directed to consider. So now, this, the issue was whether these are the genuine candidates, I mean, appointees or not. You have not said anything about the forensic report.
Yes, my lord.
So I think, I don't know, after 20 years, can we
Yes, yes, my
direct
lord.
them to appoint?
Because I'll be reinstated, Lordship will direct reinstatement because we are appointed.
So now your ground is now.
Maybe
it
may
is-
not, I mean,
this
because
is
I did
something-
not serve, I may not get the salary part, but my service will be counted for all other purposes.
Well, their services will.
Now, how old you are?
My lord,
Mhm.
50, 55, something like this. Because, since we have not served, naturally, my lord, we cannot be paid back wages. But my lord, for all other purpose, our service should be counted.
Their appointment were cancelled in the year 2001, my lord.
Yes.
That was put to challenge. There is a series of writ petition, there is a proceedings, litigations were there. Finally, things will start moving from the, I mean, this forensic report, which shows that they are genuinely appointed. And courts also directed you to find out, I mean, this segregate
Forensic-
genuine or,
Forensic report, my lord, did not say that, my lord, they are genuinely appointed. It found that their name were found in the approved list.
is it your findings in the impugn order?
In impugn order, obviously, my lord, they have not referred to
Then-
the forensic report.
Then,
But in the forensic report, their name were found in the approved list.
yes.
But it is not the case that they were genuinely appointed.
Is it, have you said anything on this in your impugn order?
No, my lord.
Then your rejection, you cannot be considered because of the change of this thing. We'll consider those relevant when in 2001, when you are not saying, when you have not said anything, when you have not about the forensic report, we'll have to.
Our rejection on the ground that, my lord, again, my lord, it is difficult to ascertain the genuine candidate, 280 numbers of genuine candidates.
Who had stopped you? You are given ample opportunities. You have not done it. Is not it? Despite repeated orders. Now court found that in the earlier proceedings, records to be seen. The moment when you say that record is available now, that was placed here and it was sent to forensic. And you have not said anything on this also.
And further, my lord,
It may be difficult, but then there's no other option, sir.
when this impugn order was passed, my lord, already 19 years has elapsed, my lord. So,
That is the reason I said, whose fault?
and by now, my lord, most
This
of them are
started in
more than
when
58 years, 59 years, my lord.
litigation started when their appointment were cancelled.
Yeah, my lord.
That's all. I mean, one and after there is a direction, intervention of this court. Let us see.
Yes.
Yes, in fact, my lord, we have submitted a written argument in earlier occasion, my lord.
Where it is.
It's in a file, main file, my lord. As directed by this honorable court, my lord, we have submitted a written argument.
Common written argument on behalf of.
There are petitioners also and the respondents also. my lord.
State, yes. Are you relying any judgment?
No, my lord.
Now matter is, it's very simple now.
Yes.
But problem is that after 24 years,
Yes, my lord.
let us see what
My lord,
relief can be
there is
provided.
a legal maxim, my lord,
Yes.
and they call it, my lord, court's order do not prejudice anybody,
Hmm.
neither them nor us. I forgot that maxim. As long as the matter is in court, my lord, nobody can claim any, neither any equity nor any prejudice. End of the day, it is court's prerogative. Diplomat.
Okay.
Obliged.
CAB. Heard Mr. Ken Chaudhary, learned senior counsel, assisted by Mr. I.S. Saikia, learned counsel for the petitioners. And also heard Mr. N.J. Katania, learned standing counsel,
Yes, my lord.
elementary.
Elementary education.
Elementary education, for the response. Any other appointments made?
My lord,
Though,
like this, Sonitpur and Sibsagar districts were made about few years back. Similar situation, my lord.
after the.
Yes,
the
yes. I think
intervention-
4, 5, this Sonitpur and Sibsagar district had similar problem.
Intervention of this court
Yes,
or
yes,
on
yes.
their own?
Yes, intervention of this honorable.
Can you have those orders?
We'll find out.
If you can find out.
Deeply. Ase, ase.
If we allow,
Yes, my lord.
your ground may not be, of course, we'll consider, but then the rules, whatever, and the eligibility and qualification will be from
Of that day.
that day, in 2000, not now. That's why they are saying that reinstatement,
Yes, my lord.
not appointment.
Deeply.
They were appointed and cancelled.
In 19. Yes.
My lord.
Big, long matter or?
No, my
short
lord, a
matter?
very short issue. It's pertaining to my lord promotion. And this, another CGC is just around the corner, my lord, just the corner. This pertains to a promotion of this lady. She is a doctor, dental surgeon, who got appointed in Assam Rifle on 29/11/2010. Now, her initial rank is assistant commander. Thereafter, my lord, all promotions are time bound. They are not neither dependent on vacancy, neither it affects anybody else's, my lord, promotional chances. Every 4 years, first 4 years, my lord, assistant commandant becomes a deputy commandant. And then after 5 years, that is total 9 years of service, the person would become a second in command. So counting from the initial date of appointment, the first promotion to the rank of deputy commandant ought to have come on 29/11/2014, my lord. Now, at that juncture, her promotion was not granted. And immediately at that point, she could not represent because she was in childcare leave at that particular point of time and some complications were there. Subsequently, her promotion came, my lord. Promotion came in 2016, 2nd June 2016. But then she requested that this promotion should be antedated and be made from 29/11/2014, when I completed my 4 years of service as per the recruitment rule. Now, the recruitment rule, my lord, is there in the affidavit of the respondents at page 66. The lordship takes up the
Yes.
affidavit, page 66.
Yes.
It says, my lord, at column 12, my lord, from amongst the dental surgeons, assistant commandant dental, on completion of 4 years of service in grade and in being medical shape 1 category and completion of basic competization training. Now, 4 years is not in dispute. Neither it is in dispute that she is shape 1. There's no physical ailment. The issue that they raised is that I had not completed basic competization training. And they say that the thing to be completed is they are referring to a course which is called MOBC, Medical Officers Basic Training. They are insisting that this is the particular course that I ought to have completed, my lord. But then the recruitment rule, my lord, only says basic competization training. There's nothing about MOBC course for doctors, my lord. In fact, my appointment letter at page 19 Annexure 1, it clearly shows that I was permitted, my lord, to join duty because this basic combatization training, my lord, is given to all persons before they join the force, so that they know, have a basic know-how about arms and some defense skills, my lord. Even though you are in a doctor cadre or in a non-fighting cadre, this basic induction training is always done. So therefore, my appointment, my lord itself says at page 19 that I have been posted at 19 DU AR and 5P after completion of basic military training. At page 19, my lord. If that be so, my lord, I had already done my basic course. The recruitment rule also says basic combatization training. Of course, there is a
Where is
difference in
it?
language that here it's
Page 19.
page 19, my lord.
Where is this?
Page 19, Annex 1, my lord, in my repetition.
Hmm.
Secondly, hereby
Offer
posted.
hereby posted to the offer to move after piping and completion of basic military training.
My lord.
There must be a difference between basic military training and combatization.
My lord, that was essentially the question that was put in Doctor of 5/8/2025, my lord, if your lordship has a book. We have been, they say that they're not distinguishing between competition and military also. Combat and military is, I understand, synonymous, almost. But then they are saying that no, you have to complete a particular course called MOBC. And if that be
MOBC
so-
what?
Medical officers.
Medical officers.
Basic course.
Basic course.
Where it is? Where the rule? Where
There's
it-
no rule.
Where it is provided?
That is in our annexer, in our affidavit, annexer J.
Page 66.
Recruitment rule.
Page 66.
Yes, Lordship, page 66, and before that, page 64.
Hmm.
This rule is applicable to medical officers and also the other military armed forces, Lordship. It is applicable for all personnel who join in armed forces, Lordship. As per the combatization course is required for every person who serve for the department, Lordship.
Where it is?
It is on page number 64, Constitution of Kedar.
Huh?
There,
Where is MOBC?
MOBC particularly that word is for medical officer basic course, and that is same with the combatization course. And
Where
we-
to get it?
That is the precise
It-
query on
it-
the order of 5/8, lordship.
it is already clear in my in our affidavit, Lordship.
Hmm.
A query
No,
is
no, your bio affidavit, your clarification do.
yes,
You have
Lordship.
to show that this MOBC is required under the rules.
My lord.
The requirement is
Basic
basic
combatization-
combatization training.
Yes, Lordship. Basic combatization course is same. Medical officers basic course and combatization course.
Where do you get it? In the rules.
Rules have to be strictly seen in that way, my lord.
In rule that is not there, Lordship, but
If rule is not there, how can you just bring in?
every person have to complete that combatization course, Lordship.
That's why.
Yes, that is the in the rule, Lordship. Here it is page 66, in page 66 that is there. Combatization course is compulsory and that course is not done by the petitioner, Lordship. Therefore, his promotion was pending. And when he completed the 4 years of 4 years, and after he is in SAPE 1 category and he complete the basic combatized course, after that he availed the promotion, Lordship.
He was given. She was given.
Yes,
On 2nd June 2016.
26,
2016.
yes,
And
Lordship.
I ought to have been given on completion of 4 years on 29.
That you have completed combination.
Yes, Lordship,
No.
he
My first certificate itself, joining itself says
No,
that
no,
I have
joining
completed. my
certificate,
lord.
it just say offer is something like it's not clear.
My lord.
See, this says that offer is offer, right?
she was offered and she refused
Offer to move after piping and completion of basic military training.
Yes, Lordship.
After completion. And where do you get that?
OFFR is, my lord, not offer, it's officer, my lord.
Officer, okay.
Officers hereby.
The officer to move after piping and completion of military training. Yes. See, MOBC. No,
He was.
from where you get that on completion of combatization training, she has been promoted. You have said so.
Yes, Lordship, she has promoted.
Where is her training completion?
Completion, and after that she's for the first time she was called for and she on page 56.
56.
Lordship. And she refused the first offer of MOBC because she was on child care leave, Lordship. That is page 56, page 56. She refused the
Application for child care leave on.
Yes, Lordship.
56.
56.
With due respect, Honorable Sir, I have the honor to lay down following.
The son actually turned out to be epileptic and therefore some extended leave was required.
They have also admitted that there is a MOPC.
Yes, Lordship.
My lord, there is a
But
course. There is a course, but then the recruitment rule is silent, my lord, as to whether this is the course that entitles me to promotion. When you
This
say
is
that,
the course saying.
when you say that you have to complete this course and only then you are eligible for promotion, that eligibility should be specified clearly in the
And
recruitment.
you
rule.
saw that you have completed the basic combatization course.
My lord,
Page
that,
19 only show that officer is to move after completion.
my lord,
Can you show that you have completed this MOBC or combatization or military training, whatever?
my lord, if the language is this way in this particular letter, this is actually the posting order. It implies Dr. Suman, newly appointed as Imam, joined on 29 November 2010. Officer BSOS, with effect from the same date. Officer hereby posted and offered to move, officer to move after piping and completion of basic military training. So on this message is of 6 December 2010. So on that particular date, my lord, my training should complete. By this message, my lord, I was, my lord, posted.
That is only familiarization course, Lordship, to familiarize the petitioner, personnel to the armed force, Lordship.
So what is
That
this
is not
basic
combatized course.
basic
That is not combatized.
combatization training?
The combatization training is conducted with armed that is the different types of trainings are there, Lordship, which are given to the other military forces, Lordship. That is compulsory for each and every person.
And for medical, for dental.
Yes, Lordship.
for
Dental,
medical
yes,
officers.
Lordship. Medical officers also require that training, Lordship.
So,
And this training period was 12
you-
weeks,
so
Lordship.
that is called MOBC.
MOBC, yes, Lordship.
This,
For medical officers, that is called MOBC, and for other personnel, that is called basic combatized course, Lordship. Same,
where do you get it?
this rule is applicable to both medical and other
This is only for medical, but then across all paramilitaries.
Yes,
All
Lordship.
paramilitaries.
Whole paramilitary forces, Lordship. That for the required that.
Because as far as civilians posted, my lord, to armed forces, my lord, arms familiarization and training initial is always done. So there is actually, though they don't go for combat, there is actually no non-combatized post as such in forces as such.
But combat.
So everybody is
and training
otherwise
is
to be
required.
ready to be done. And MOBC, my lord, the name itself suggests, my lord, MOBC is a basic course for dental surgeons, my lord. So therefore, I think the court had pointed out, my lord, that specific query on 5A, that on precisely on this point, that it seems that there has been a
Kindly-
course done.
Five?
And if 5/8/2025, Lord, you would see.
Yes, Lordship, in this regard, this query, Lordship,
Petitioner was not considered for Muslim Union as he had not been the MOBC due to child care. Yes,
Lordship, in this regard, we have already filed our affidavit, the annexer.
additional.
No, no, Lordship, in origin, in our one affidavit, Lordship, annexer M, page 73. This query is raised by the petitioner, and that is sent to the MH, Ministry of Home Affairs, and after that, it is kindly read paragraph 2, Lordship.
After this order thing, order 5/8/2025, after this order.
No, 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 Lordship, it is earlier than.
No,
this
that's
order.
why you were
There-
directed to obtain instruction.
Yes, Lordship, that instruction I have received, but that is same instruction, which is I have annexed already in our affidavit, Lordship. This is
Saying what?
Lord, page 733, last line says that you are requested to kindly forward the authority wherein
Then-
Assam Rifle has identified MOBC with the course.
then next page, Lordship.
Mandatorily undergo.
Then like next page 74, let's see. Kindly see, point 4, basic training course in medical officers and dental officers is minimum 12 weeks, 12 weeks, Lordship. And which course is completed by, done by the petitioner in initial stage, that is only 1 week, Lordship.
2 weeks. It was in
Weeks,
6
yes. Yeah, this
to
is-
20 December, 6 to 20 December.
Basic training course in respect of medical officer and dental officer is minimum 12 weeks.
This does not say MOBC, but then if they say 12 weeks again, then on what authority, my lord? If something is there in the recruitment rule, either there has to be a circular on this issue clarifying, or an executive instruction at least that this has been inducted as a basic course. It has to be, if this is the course, my lord, MOBC may be the course also, my lord. But then if that is the course, there has to be some clarification given to the recruitment rule saying that this is to be read as part of the basic eligibility, because you are fixing a basic eligibility for promotion. It has to be notified somewhere.
This is by clarification by you only. It should not be supported by the rules. You may be correct. If it is the basic, if it is equivalence to basic combatization training
Yes, Lordship.
for the doctors,
Yes, Lordship.
you'll have to issue something.
That particular MOBC.
And how she has been promoted subsequently?
After that, she completed the MOBC, Lordship.
Where do you get it?
Promotion letter.
A writ petition is there, Lordship.
Annex 5 is otherwise part of that MOBC, my lord, training, because during service, every year, numerous trainings have to be done, my lord. Now, how do I know that this particular training is basically my eligibility for promotion, my lord? Unless it is
Of course,
clearly, my lord.
the not publishing
My lord.
the requirement or equivalency
Yes,
or
yes,
whatever
yes,
maybe,
yes,
maybe irregularity, but then facts as per their clarification remains that appears to be MOBC is equivalent to combatation training, basic combatization
That's a
training.
clarification on affidavit only, my lord. It has to be supported by sometimes recruitment rules are not complete. Sometimes recruitment rule might be silent on a particular aspect. And therefore you need a notification thereafter, my lord, to say that this is, my lord, clarified or this is to be added and these are the basic.
No, you may be correct, but then facts remain that this is a requirement. Or what she is saying is, though recruitment rule doesn't provide the MOBC, but for doctors,
My lord.
MOBC is the.
Who had, my lord, made this rule, my lord? If it operates as a rule as to my basic eligibility
Then you
for
saw that you
promotion.
have completed in that case, you also saw that you have completed the basic
My lord,
combatization training.
This, my lord, the letter that we read, my lord, right now, page 73, they were referring to, I think. And thereafter 74.
Training for another
74.
cannot be equated as
My
mandatory
lord,
training for
they said that
promotion.
I had undergone for 2 weeks.
Hmm.
But then they said, no, it should be 12 weeks training.
Hmm.
Where is the authority for that, my lord? That this is the eligibility criteria for promotion. When you talk about promotion, my lord, the eligibility criteria should be crystal clear. If not in the recruitment rule, there has to be instruction. Therefore, the court asks that what is the authority you place it? If they don't have any authority, my lord, let them put an affidavit also to that extent that we don't have any authority on this. But then we have, by practice, my lord, made this a rule that you have to do for 12 weeks, not just 2 weeks. Because it's a time-bound promotion, my lord. Why it is rigid interpretation, my lord? If the rules are unclear, my lord, it has to be interpreted in my favor because my promotion does not affect anybody else. It's not a vacancy-based promotion that would affect somebody in the entire line, my lord. If there is no instruction as per the 5-8 order, my lord, let them put it on affidavit that there is no clarity on this. That would make us easier for us also to, my lord, respond.
You may be correct.
My lord.
You're just simply clarifying will not do.
My lord.
Because this is based on the rules.
Rules.
Yes, Lordship. And
It cannot be verbal, my lord.
rules says that it is applicable to for all medical officers. And that is medical officers basic course, which is instructed that, but here already says that combatized course. That is medical.
Who has said so? By which
Rule says-
author?
Rule
Which author?
says
Rule says what?
combatized from among the dental surgeon assistant on completion of 4 year service. In dental surgeon specifically mentioned, Lordship.
Yes.
4 year service in the grade and being in medical category shape 1 and on completion of basic combatization training. Where he has completed basic combatization training, not completed, Lordship.
Where is the basic
Yes,
combatization?
in rule, Lordship.
That's what I'm saying. Rule says basic
Combat-
combatization the training.
Yes, Lordship. He had not
You are
completed
saying MOBC. What is MOBC?
medical officers course. That is same.
How can you say that?
When you read something as part of the recruitment rule, it has to be notified.
When in the recruitment, does it say that this medical officers basic course?
Yes,
is it?
Lordship.
MOBC
That
what?
specific word not there, but he has not completed the basic combatized training, Lordship. That is he not
And when
completed.
when did she complete?
It's, when he is 2014. He completed
I was sent to MOBC course in May 2016.
June 2016. Promotion is again 15/6/2000. 18 to 2016 to 24 2016. And the MOBC. Yes, that is basic combatized course he is completed, which was conducted held during the 18
From where you are saying?
2016
Where
from
are-
his petition, Lordship. From his petition. One.
Very difficult.
Annexure 5, Lordship would see, page 24. This is the only record I have like for attending this particular course. Because the officers are sent for numerous courses, my lord, throughout the year, my lord. My issue is that how do I know that this is the course that was a eligibility criteria for promotion? Even today, there is no clarity, my lord. Attended MOBC 208. at
Where is
Himalayan
your
Institute
promotion
of
order?
Trading it.
Where is your promotion order?
Promotion order. Annexure 6, my lord, page 26. Promotion of assistant commandant to deputy commandant. It came in effect from 2nd June 2016.
You want from 2014?
I won from 29/11/2014, my lord. Because 4 years, as per the RR, because it's a time-bound promotion, every 4 years I have to get promotion, my lord.
12 August 2016. Then this is, promotion is?
Promotion on, promotion came, my lord, on second, from with effect from 2nd June 2006.
2016.
Order issued in June 2017, but then given effect from 2nd June 2016.
Second June?
2016, my lord.
Why?
They say that on that day I completed MOBC.
Yes, Lordship.
2nd June.
2nd June.
But annexure 4 to page 24 says 12 August.
Yes, my lord, that's, otherwise, my lord, how this particular date was arrived at also, we don't know. They have given effect to, as
Date
per
of
their
release.
affidavit in that manner.
When he was completed the combatization course, after that,
When?
Yes, Lordship.
When she did complete?
That is on
12 August.
in 6 20 April to this 2016. He has completed. Attend MOBC. He attend MOBC from 18 February 2016 to 20 April 2016.
Therefore,
12 weeks course. After that, his promotion was granted.
with
Lordship.
effect from?
2/6/2016.
So promotion is from the date of completion of that MOBC.
My promotion order doesn't say so, and I don't know why this 2nd June date was also fixed. Now on affidavit, they are saying.
Completion of 4 years of his service, Lordship. He was appointed on 29 November 2010. After that, he was called for MOBC. His promotion was due on 2014. And that period, he was called for MOBC, but she refused a training course, Lordship. After that, then 2 times she was refused. After childcare leave, when she joined in the force, Lordship, after that, she again called for MOBC in 2008, effect from 18 to 16 to 24/16. Then, after that, completion of his course, he was promoted.
But
Was promoted, Lordship.
then which effect from what? From date of effective date of promotion?
Annexer 6 says, my lord, without reference to this MOBC course, it says it is with effect from 2nd June 2016.
2nd June.
2nd June 2016.
Why 2nd June 2016?
That I don't know, my lord, because it has no reference to course at that point of time. Then when I represented, my lord, and this writ petition came, then this MOBC story, my lord, is coming up. And that training, of course, I missed, Lordship had seen the child turned out to be actually epileptic, and so therefore extended leave was to be, my lord, taken.
She admitted that she was not able to attend the MOBC basic
Yes,
combat
he's
course.
but problem is that where is the requirement of that MOBC course? Under the rule, that is the whole problem. And even if it is silent,
Yeah, it is already clarified from
not
the
by your
ministry.
letters, madam, we'll go by the rules. Obviously, you will clarify.
And if any ambiguity is there,
See, it's very simple.
Yes,
Rule
Lordship.
provides the requirement of other apart from other thing, the basic combatization the training. You are saying that this basic combatization training is equivalent for medical or dental officers. You will have to be will have to complete the MOBC.
Yes, Lordship.
Where does it say? Except apart from your clarification by officers.
That is here in rule, that is not there.
If
But
his rule is not there, what can we do?
no, but Lordship, does not complete the combatized course also, which is in the rule, Lordship.
Where it is?
In rule, that is there, he must be complete the combatization course, Lordship. That combatization course, did not appear. When after completion of that course,
That cannot be.
was promoted.
See, there in that case, your submission is contradictory. Either you should say that you should your stance should be either she has not completed the combatization training,
Yes, Lordship.
or you have to show that the combatization training is akin or equivalent for the medical or dental officer MOBC, that you have to show. Admitting, let us assume, I mean,
Yes,
admit
Lordship,
for a
can-
time being,
Can I,
Except-
Lordship? Yes,
that for medical or the dental officers, instead of basic training, a basic computerization training, if it is MOBC, you will have to clarify by way of circular, office memo, whatever, because it doesn't clarify the rules, right? That has to be clarified by way of circulars. Or this has not been done.
yes.
There's nothing on record to show that there's any circular to that effect, clarifying that for the purpose of this rule, I mean, this requirement of basic
Yeah.
training of a computerization training, then it should be, it is MOBC course, MOBC, that at least some semblance of notification, circular, whatever, any clarification can be given. Right,
Yes, Lordship, but
which you have not done, except clarification by the officers. Maybe it may be correct, but it has to be
Yes,
not the
Rules cannot be oral. Qualification cannot be prescribed orally, my lord, without there being any.
basic computerized course is compulsory. But she does not completed that course. The promotion was granted to her after completion of that course,
what course?
basic computerization
What-
course, which is called same MOBC also.
It's back to square again. That's what I'm saying. Maybe correct,
Yes, Lordship.
actually. But you are relying on these rules. There are certain rules which regulates the promotion. It has to be published. Officer has to know
See, in this.
what exactly is the requirement.
Yes, on this point, she has made query and file representation before the authority. And authority also clarify it and send it from it, Ministry of Home Affairs reply this, her query, Lordship.
Where
It
it
is on page 61, Lordship, of our affidavit, Lordship.
61.
Yes, Lordship.
Query on promotion, huh?
Yes, Lordship.
DG Assam Rifles.
Yes, Lordship.
Yes.
Page 62, I think, is the reply, my lord, from MHC. There is a note.
It is to say that promotion to the post can be done as per the
MHC has requested for clarification. And it simply says proposal has been
promoted the
examined.
rank of deputy senior dental surgeon on completion of 4 years service in the grade of assistant command dental surgeon in place of 0622, that is completion of basic competency training as prescribed in RR. That's why I'm asking 0206-2016 is what?
Appointed dental surgeon.
As requested for clarity on the following. Dr. Suman can be promoted to the rank of so-and-so in so-and-so with effect on 28/4/11/2014 on completion of 4 years service in the grade of in place of 0206-2006 completion of basic computerization training as prescribed in RR. Whether she can be considered for promotion. The proposal has been examined and it is to say that promotion to the post can be done as per the complete, what is this?
Eligibility criteria prescribed in
the
RRs.
Since RRs prescribed for, what is this?
Training or eligibility criteria for promotion. Therefore, the promotion can be made only after completion of training. Further, the promotion to the post of 2IC should be as per eligibility criteria in the prevailing RR. So they just simply refer back to the RR, my lord.
Point four, the officers completed medical officers basic course as AMC Center and School Lucknow from 18 February 2016 to 1 June 2016, which as per medical branch DGAR is the basic combatization training. That all
Where you are reading?
page 61 point
Page 61.
number 4 point point four. The officers completed a medical officers basic course MOBC at AMC Center at School Lucknow from 18 February 2016 to 1 June 2016, which as per medical branch DGAR is a basic combatization training that all Assam Rifle officers of medical and dental cadre undergone along with the AMC and ADC officers of the Indian Army.
Your clarification, it's okay. We have understood.
Yes, that's it.
The authority behind, my lord. That is why the court gave them time to take instructions on the authority, my lord, based on which.
From where you are saying? Is it just a practice or what? Any circular to that effect?
Today, MOBC word is not there, Lordship. Today, nowadays, it is.
Give you a
Yes,
further time,
Lordship.
we'll keep it part hard.
Earlier-
Let us do one thing.
My lord.
Your clarification, I've understood.
Yes,
You
Lordship.
are making your submission on the basis of the clarification by the officers or
Yes.
whatever.
Yes,
Minister of Home Affairs also, it's not that, let's say this as per the
It will
rules,
be as per RR.
doesn't clarify MOBC and all. I think there should be something, some circular, some office member and that which says that for this, obviously the basic training, basic combatization training
and
may not be required for the dental officers or the medical officers. They don't
What is basic
competing.
military or para?
So
what is
maybe
basic-
there may be some orders that which shows that for dental and all this thing, which you have said so.
yes, Lordship.
There must be some circular. If there is a circular and all, then we
Because
can
if-
consider
My
that.
lord, if this is a eligibility, it has to be notified because I have to know what are my eligibility for
You
promotion.
wait on that. You file an additional affidavit.
Yes, Lordship.
And as far as
If
military.
there is any circular and all that, from where you are saying that
Yes.
this is for dental, this is for, accept your explanation.
Yes,
Explanation we have understood.
My lord.
yes.
All right. When? And Mr. B. Pathak, learned counsel for the petitioner. And also had
S.
S.
Borua.
Borua, learned CGC. What is the recruitment rule?
Lordship will look
The-
at page 66, my lord.
Rule,
The rule starts from page 64, annexes A, my lord.
the recruitment rule for promotion to the, what recruitment rule, what do you call it?
This is called, my lord, Lordship would come to page 64. It's called
The
Central
central
Paramilitary
paramilitary
Force
forces combined within bracket dental surgeons,
Cadre.
bracket close, cadre recruitment rule 2010 provides that
For promotion.
for
to
promotion to the what
Deputy Commander,
commandant from
Assistant Commander.
assistant commandant, the dental surgeon, a big assistant commandant dental the qualifying 4 years of service in the grade and being in and with medical category safe one, nah? Safe SH
one.
AP AP, huh? Capital, huh? This Roman one. And on completion of basic combatization training. Next para. Although the respondents have clarified by an explanation that for dental officers, the combined requirement of the basic training, the basic combatization training, the officers has to undergo medical officers basic course, basic course.
Basic.
Comma, it is not, no records is, there's no record to show that the basic so that MOBC is equivalent equivalent to basic combatization force as required under the rules. But this rule is Mr. You also.
This is applicable to all paramilitary forces.
No, these rules may be called the Central Paramilitary Forces combined within bracket dental surgeons cadre recruitment rules.
I'm a dental surgeon, madam.
Huh.
This rule is applicable to all paramilitary forces.
Paramilitary
Active,
of-
CRPF,
Ah.
BSF, everybody.
Yes, that is I am saying that the.
Central Paramilitary Forces, all for the dental surgeon only.
Yes, only for the.
Yes.
And why combatization is
My
required?
lord, what happens is that whenever you join armed forces, a basic induction training about arms is given. So that you are familiar as to certain operation procedures with them. I don't go to the battlefield.
In view of above,
But then just why not to have an idea about operations of the forces.
in view of the above, the MS and S. Baru and CGC to file an additional affidavit clarifying the stand of the respondents and may bring on record any circulars or office memorandum issued to that effect, huh, Mr. Mr. Matter, after 3 weeks
Yes.
as a partner, because you have spent.
Hopefully the bench should be there, my lord. There's no roster only after 3 weeks.
Not
we'll
there,
make an effort.
if not there, we'll.
My lord, we'll make an effort, my lord. We'll make an effort.
If not there, as and when,
My lord, my lord.
will be listed.
Yes, my lord.
But clarify that.
Yes.
We'll
Because why I am again emphasizing, lordship had seen that the clarification, what I argued the other day also, which led to this order. This rule, lordship had seen is the MHA rule applicable across all paramilitary forces. So this criteria to be fixed, this cannot be as per medical branch officer's instruction also. They say that we have done so as per AMC and so and so. That page 61 that they were reading.
We'll say, we'll determine.
My
Let
lord,
them-
my
let
lord.
them, let us give them one more chance
My lord.
to clarify.
Some other day probably, my lord.
Hmm?
Some other day, my lord.
24.
24. In fact, Learned CCC was also busy all day arguing.
24.
Item 24. This also pertains to promotion.
Low medical category.
No medical category.
Then 25.
25 is
Huh?
not mine, my lord.
On the prayer, Mr. B. Patel
ये तो है।
and Mr. B. Patel Learned Company and Mr. K. Parasar.
ये बात नहीं कर दिया था ना उसको जो।
CGC.
My lord.
Let me see. List this matter after 4 weeks. Ah,
My lord.
4 weeks.
3 weeks, not a short matter, my lord.
3 weeks.
He was actually given promotion. Then, before I joined, my lord, he was considered by the DPC. And on the date of DPC, I was medically fit. Thereafter, they said, oh, no, I have hypertension, so promotion cancelled.
They rightly done, sir.
My lord.
Rightly done, sir.
Obliged, my lord.
Here the issue is, madam, the petitioner already is CSF constable was removed from service.
Ah,
Mainly, madam, the only issue is, madam, proportionality of the punishment
hmm.
imposed by the department that is to be considered by this court, madam. This is the issue. Madam. Very
Some,
limited.
some other day.
Should we fix it?
Dismissal. Removal.
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 Okay. And Mr.
MA Islam.
M.A. Islam, London Council for the and Mr. K. Gogo, London CGC. As great for London Council for the party. Let this matter list after 4 weeks.
Lordship, no, my lord, since the petition is out of service, my lord, since 2022, my lord.
Hmm.
So, my lord, lordship may have the matter fixing a date, my lord. Otherwise,
After 2 weeks.
it's
3
very
weeks.
difficult to get the
After
matter.
3 weeks. It will be listed, don't worry. Right. Hmm.
15 December. All right. No, my lord, before or after 15? No, no, no.
December চোন
15 December.
থাকিব দিয়া থাকিলে কৰিম নাথাকিলে নকৰো আৰু
তাৰমানে 15 December মোৰ কেটৰ দুটা মেটাৰ আছে।
হ'ব দে একো নাই